Heidi ho, chickadees. We're back for the afternoon session. I had a lovely lunch. Mr. Demeanor was kind enough to get my favorite, which is fast food. One of my favorites. And so I got myself a nice McDonald's quarter pounder and some McDonald's French fries. Love those two things. And I am sipping now on some hot apple cider. I have to tell you, this apple cider is from the great state of Michigan. Some friends of mine visited there and brought it to me. So I'm super excited to be drinking it. It is fantastic. If you've never had hot apple cider, you don't know what you're missing. It's so good, especially if it's fresh. So we're going to get closing arguments, jury instructions. What? What? Someone from the Twix says they can't see me. I don't know why you can't see me, Lori Jean. Oh no, I don't know why. Let me know. I'm not doing anything different for the Twix. I'm so sorry. So you can hear me but not see me. I don't know how to fix that. Everything looks like it's okay on my end. I guess let me check on Twix. Hold, please, everyone. We're going to try to diagnose this live. Oh, you can see me on YouTube, but not on X. Well, I'm on the X. I'm on the Twix. That's what I just pulled up. So, I'm there. See? Yeah, it's. Oh, hello, the trial channel. Okay, yeah, I just checked. I can see me on X as well. So perfect. Anybody that's watching on X, make sure that you pop on over to YouTube, give me a like, a subscribe. And Lori, yeah, I think there's something going on with yours instead of just here. And we've got Melissa back with us this afternoon. Free Kelsey is. We won't tell anybody that you're listening while you're at work. I know how that is. And the trial channel, who has been fantastic in letting us use all of this fantastic coverage. So I do appreciate all of you for tuning in for the afternoon session. Before we left for our lunch break, I asked you all if you wanted the jury instructions as well. And it sounds like everybody wants the jury instructions. So we're going to go ahead and do that. I may have to pop off to another feed to find that for us. But we will do that definitely. Okay. Everybody ready? I think there was a legal argument. So we're going to go ahead and finish that part. And then we'll get into the closing arguments. Is everybody ready? I'm ready. I hope that I don't have to listen to the prosecutor scream at me because it made me feel a little traumatized.
Actually, I should send the jury. Do you want me to send the jury home at this point? Or?
That's fine. No objection, Your Honor.
All right. So the court is going to release the jury for today. Okay. So I just want to remind you that we are at the part of the trial where you have heard all of the evidence that you're going to hear in this case. However, you've not yet heard closing arguments. You've not yet heard the instructions regarding the law that you're to apply to the facts you find in this case. As such, as in my prior instruction to you under your oath, you're not at a point where you can discuss this case with anyone, including each other. So you're not at that point yet, despite the fact that you've heard all the evidence. So it may seem natural that you are at the phase where you can talk about this with your fellow jurors, but you cannot, all right? So you need to continue to abide by that instruction until such time that I tell you that you are able to go ahead and conduct your deliberations. So we are going to adjourn with respect to the jury right now. For the day, you are able to leave. Again, we will not be having court on this matter tomorrow, and that's due on July 3rd, at which time I would anticipate closing arguments and the instructions, and then after deliberations by you, the jury. Okay, so please, again, remember not to discuss the case with anyone, do not take in any information about this case, try to avoid the media as best as you can. There is media attention on this case that includes social media and news coverage, so if you can please avoid those, are would much appreciated, so we don't have to deal with any conflicts when we come back. Also, again, there have been locations that have been discussed. Do not do any drive-bys, do not look up any locations via any alternative mapping device. And last but not least, please do not conduct your own independent research or investigation into this case, because you are going to be instructed to decide.
Thank you, Sarah Ellen.
The evidence presented here in this hearing. With that, have a good afternoon, have a good day tomorrow, and we will see you back on Thursday. Thank you so much for your continued attention. Attorney Smith, you wanted to present legal argument.
Yes, Your Honor. At this point, we would move for a motion of judgment of acquittal under Practice Book 42-42. The state's evidence has closed. We made our motion at that time. We've now heard from Mr. Valle, and I would renew my motion, and I would direct the court to cases of State versus Carpenter.
We did not watch the motion for judgment of acquittal, by the way.
Thomas 210, Con 199, a 1989 case. And the standard here is well known to the court. This is to be viewed in the light most favorable to the state. But even when viewed in that light, this evidence is insufficient for this jury or any jury to find beyond a reasonable doubt that Mr. Valle had the specific intent to murder anyone, that Mr. Valle had the specific intent to assault Tommy Connery or to assault Ryan Hines, and more so even with regard to Mr. Faison Teal, which is the assault in the second degree charge. The evidence as to Mr. Teal, candidly, is we heard the least about it. We really don't have any indication of what the mechanism was. Mr. Teal couldn't be sure how he got cut or what exactly it was that cut him.
True.
And we haven't heard any evidence of anybody viewing that happening. And so it has to be simply an inference that a juror would draw that in the course of this brawl, in this chaotic scene, that somehow Mr. Valle cut Mr. Teal. I would submit that that is an inference that is unreasonable to draw on this evidence that we have before us.
Faison was McDonald's
Specific
man.
intent is not simply general intent. So the fact that Mr. Valle has testified here that he was flailing around with the knife trying to defend himself is not sufficient to show the specific intent to stab Tommy Connery, the specific intent to stab Faison Teal, or the specific intent to stab Ryan Hines, or the specific intent to stab Jimmy McCracken. As to the other elements, candidly, we have conceded those elements by raising a self-defense claim. That doesn't, however, mean that the state prevails, even when you view this evidence in the light most favorable to the state. That they have shown, beyond a reasonable doubt, for these fact finders, that Mr. Valle possessed the specific intent to murder or to assault any of the injured in this case. Consequences are tragic, but it simply doesn't tip the scales any further and allow this jury or any other jury to find, again, that the state has proven specific intent. The evidence there is equivocal at best, but in no way does it reach that highest standard and overcome it. We would ask the court to grant the motion for judgment of acquittal as to all the charges.
Your Honor, thank you. I would just first start by saying the defendant has testified and is now subject to the same credibility instruction that every other witness is subject to when you charge the jury. The jury is free to believe all, some, or none of the defendant's testimony. And that's
Yeah.
up to the jury. I
Yeah.
would submit that there are a lot of inconsistencies in the defendant's testimony, and I would submit that the defendant was caught in a lie multiple times in his testimony. And I would submit
Was
that
he?
would have an impact on this jury. With regards to the defendant's specific intent, should the jury believe that the defendant went back there with a knife, his intent was purposeful, and that he took that knife out of his right pocket, opened it up, and started stabbing the people that were before him. There was evidence that Faison Teal, Ryan Hines, and Tommy Connery were in the vicinity of where Mr. Valle was. He stabbed Ryan Hines and Faison Teal first. They were stab wounds, not slashes. So the jury can infer from the circumstantial evidence from Faison Teal that his wound was a stab wound, purposeful, not slash. There was some testimony from doctors with regards to that. The jury could also view Mr. Hines' evidence that he was stabbed purposefully this way, not a slash wound, flailing around. The jury can infer the defendant's intent from that. With regards to Tommy Connery, there was evidence that the defendant was down almost on one knee, that he purposefully went at Tommy Connery and stabbed him 4 times in the leg. And with regards to Jimmy, after he came back from the car when Mr. De Silva was no longer in harm's way. He turned right at Jimmy. He purposefully went out there and stabbed him in the heart. Didn't slash him, stabbed him. I would submit that the jury's going to get an instruction that intent can be formed in an instant. And they can also infer from the circumstantial evidence, should they not believe the defendant's testimony, that the number of wounds inflicted, the area of the bodies where the wounds were inflicted, all points to the specific intent of the defendant on May 14th of 2022. So I think when you view all the evidence in light most favorable to the state, Your Honor, I think the defendant's argument fails, and I would ask to be denied at this point.
So this motion being made at the close of evidence in accordance with our rules of practice, the court is going to take the motion under consideration and defer a decision until the jury returns its verdict.
All righty. So that was the end of basically the trial. So let me get myself organized here. And we're going to go to closing arguments. Bear with me, everybody.
I think the more likely thing.
And what's interesting to me, so we're just now finding out that there was indeed a self-defense claim. I wasn't sure of that. I assumed there was, but interestingly enough, in the state of Connecticut, where this particular case was tried, in criminal trials only, the attorney's counsel is given the option of whether they want to do an opening statement. Only in criminal cases. In a civil case, there is no opening statement, which is bizarre to me. But anyway, they opted in this particular situation to forego an opening statement. And so that's where I feel like I would have gotten that information if that the choice was made for him to have a self-defense claim. So I'm anxious to hear how these closing arguments are wrapped up. I don't buy the fact that Raul Valle was caught in lies on the witness stand. Y'all let me know in the chat, but I didn't pick up on that. And I want to hear how they're massaging the testimony and evidence into something that makes sense, because it looks like self-defense to me. And then I want to know about the jury instructions of how is the jury supposed to go down those findings in order to find guilt, and how the self-defense and intent and all that plays in. So, and Jay Cornish is right. Yes, please smash the like button if you haven't already. And we're gonna just head on in.
Court's now in session. The Honorable Judge Murphy presiding. Good morning, Your Honor.
Your Honor.
Good morning, everyone. You may. The purpose of the record, we are here today to continue the trial in the matter of State of Connecticut versus Raul Valle. At this point in time, I am going to ask counsel to please identify themselves for the record.
Good morning, Your Honor. Mark Joseph for the state of Connecticut.
Good morning, Your Honor. Counsel, I'm the state of Connecticut.
Good morning, Your Honor. Kevin Smith for the defendant, Raul Valle, who's at my side.
So, court would just like to note for the record that the court did prepare a draft jury charge, which was presented to counsel for review. Prior to closing arguments this morning, we're taking a brief informal conference with counsel regarding that particular jury charge, which will be marked as part of the and put in the court file as a draft copy of the jury charge. I do usually go through each of the sections just to determine whether or not there are any questions or any changes or requests that have not been made to the charge in accordance with anything submitted by counsel. So I'm first going to start with the state and ask the state, did you have an opportunity to review the draft jury charge that was provided to counsel?
The state has had an opportunity to review the draft, Your Honor.
All right, and let me
Y'all can't hear me if my mic is muted. Durr. Bear with me just a minute. I am going to get us to the actual closing arguments, because what they're doing right now, while fascinating at times, I am not terribly interested in at this point. And if you are, I'm sorry. You can go back and watch it yourself if you'd like. But I want to get to the closing arguments. So I think this is where we need to be.
Ladies and gentlemen, you're now back to your closing arguments on behalf of the parties. The state will have the opening or first argument concerning closing argument, and the defendant will have an opportunity to also make an argument to you, and then you will hear from the state again, perhaps. It's my understanding that you will hear from the state on this particular case. Now, although the state has two arguments, both sides get the same amount of time to present their argument to you. That time is a total of 1 hour. The state gets 2 opportunities to present to you because the state does have the burden of proof in this particular trial after all. So we will hear from the state, we'll hear from the defense, and we'll hear from the state again. There may come a point in time where I have to interrupt defense counsel if timing is off a little bit. So please don't hold that against anyone. That's my fault. So I hate to interrupt, but I'm not happy. All right, we'll see how the closing arguments go, and then we'll decide what we're going to do out of the on that. Thank you so much for your continued patience, as well as your.
So these closing arguments are timed.
Lastly, I see a lot of you with your notebooks, and that's my bad. I should have had the third statement on you. So I'm going to ask you not to take notes and to instruct your speaker during closing arguments. And the reason that I do that is because closing arguments are not evidence. Remember, what the attorney say to you is not evidence. So you've heard the evidence that you're going to hear in this case. This is the opportunity for counsel to argue to you. So I won't have you take notes during this time. I would ask you just to pay attention to counsel, listen to the arguments, and then I'll have an opportunity to address you. Thank you so much. I would agree.
Thank you. Good morning, ladies and gentlemen. So I was actually just going to address that arguments are not evidence. This is argument, right? You've heard all the evidence that you need to hear. At some point in time, you're going to decide this case based on what you heard in court. But I wanted to take a moment to thank each and every one of you for giving us your time. It's been 2 weeks, over 2 weeks. All of you have listened diligently. You've given your time. You've given obviously your lives outside of this court are more important. But this is a very important civic duty, and it does not go unrecognized. So we thank you very much. As the court indicated, this is my first of 2 opportunities to talk to you about this case. And in this case, there have been many witnesses who testified. This happened 3 years ago. They provided different perspectives on what they saw, what they heard, what they did. And the majority of the witnesses were teenagers when this happened. It was a horrific event. But the main story is the same. The main story is the same. The horrific event that was etched in their minds was the same. This case is not about who did it, what happened, how it happened, when it happened, what happened.
What
This case
happened?
is about Raul Valle, the defendant, who brought a knife to 43 Laurel Glen on May 14th of 2022 and provoked a fight and stabbed 4 kids 9 times, killing 1. That's what this case is about. So what happened on May 14th of 2022? You heard testimony about this party at Lazy Brook, where it was a St. Joe's party. Kids were hanging out. They were drinking. Typical high school party. Probably not the first time there's been alcohol at a high school party, right? Not that anybody's condoning it, but it happens. So there's this party. The defendant's there with his friends. He's wearing this helmet. And in come in some Shelton High School kids, Ryan Hines and Griffin Marcinzik. And because this is a St. Joe's party, not a Shelton party, they can't come in. So the defendant and Mr. Snyder and DeSilva take it upon themselves to kick them out. They steal the beer from Ryan Hines. At some point in time, it gets heated. They're arguing back and forth. And at some point, it ends out into the driveway. And when it's out into the driveway, there's this agreement. I'll fight you for my beer. So Jack and Ryan square up. And just as they're squaring up, who starts the fight? The defendant starts the fight. He sucker punches him in the back of the head.
Oh, the
And then after he
push.
sucker punches him in the back of the head and the fight goes to the ground, he takes his helmet and uses it as a weapon and slams it into Ryan's head. You heard the defendant testify. He would have to believe that that was a push, that he pushed Ryan Hines and that he didn't hit him with the helmet. I would
Sir, we
submit to
think
you
it was a
that
push.
If you watch that fight, you can judge for yourselves what you see in the fight.
We think it was a push.
And by the way, while I'm talking about witnesses, the judge is going to give you a credibility instruction, right? You're all going to have to assess the credibility of each and every witness who testified. And if you recall during voir dire, I think I asked each and every one of you the same question. You think it's possible that somebody could get on the stand, raise their right hand, and tell the truth? And you all said yes. I also asked all of you, do you think it's entirely possible that somebody could swear to tell the truth, believe they're telling the truth, and simply be mistaken about something? And you all said, yeah, that's possible. But I also asked you, do you think it's possible somebody could get on that stand, swear to tell the truth, and look all of you in the eye and outright lie to you? So again, when you're assessing the credibility of each and every one of the witnesses who testified, that's what you have to go through. You have to go through what they said and how does it line up with the rest of the case, right? The defendant who took the stand is also subject to that same credibility issue. He put his credibility in issue as soon as he took that oath. The video I would submit to you tells a very different story than what the defendant testified to a couple days ago. So after this fight, they get in Jack's car and they leave Ladysbrook and they go to Trumbull High School. And at some point in time, as they go to Trumbull High School, there's this basketball group chat. You heard testimony that Shelton kids were in it. You heard testimony that Ryan Hines was in it. You heard testimony that the defendant was in it. You heard the testimony that De Silva and Snyder were in it. And you also heard testimony that they wanted to fight the Shelton kids at Trumbull High School. They were there for about 20 minutes. This wasn't over. Of course, there was argument and heated emotions about what had just happened at Lazy Brook, but now they want to meet up at Trumbull High School. So what does the defendant say? The defendant tells them to slide on over to Trumbull High School multiple times in the group chat. Slide right over because they want to fight. Shelton kids don't want to go to Trumbull High School. Somebody puts an address, 43 Laurel Glen, in the group chat. Come to Laurel Glen.
Somebody.
So they go over to Laurel Glen. The defendant would have you believe that he had no idea that they were going to fight, that they were just going to another party. I would submit to you that you need to assess whether or not that's credible during your deliberations. But in any event, you heard testimony from several witnesses that the defendant wanted to go to Lazy Brook or Laurel Glen to fight. He wanted to fight at Trumbull High School and he wanted to fight over at Laurel Glen, and that's why they were going. And as a matter of fact, when they got to Laurel Glen, the defendant lets all the kids know that they're there.
Did he?
There's a few kids outside, more kids come outside, and at some point in time, Tyler Rich and his friends are outside. They're around the car in front of his house at 43 Laurel Glen, and there's some testimony that at first it was peaceful, some testimony that it got heated, arguing back and forth, things were being thrown. You heard testimony from Aiden King. I saw Raul sitting behind Jack Snyder, who was driving. Tyler De Silva was in the front seat. The defendant even said Aiden King's his boy. And Aiden King got up here and said, at some point in time, the defendant said, "Get your friends away from my car. I'm going to break a bottle over somebody's head." Again, all of these things going to what was his intent that night.
If you believe all of them.
So things are thrown at the car. The car was being shook by the Shelton kids. There's some testimony that things were being thrown back. Car takes off, drives up and down the street. Things are thrown from the car, things from being thrown at the car. At some point in time, they end up at the end of the street, close to the intersection of Farmhouse Road near 36 Laurel Glen.
What are we doing, sir?
This is 11:40 at night. You heard testimony. This is Jack Snyder's car. The defendant's already out of the car. Tyler De Silva gets out of the car. I would submit to you that the defendant being mad, angry about what had just happened to Jack Snyder's car happens just prior to this video starting. And that's a point when he asks him for the knife. He asked him for the knife. He said, "Jack, give me the knife. Where's that knife? Give me the knife." He gets out of the car. Tyler De Silva gets out of the car. Keenan, Dimitri, Will, Mackenzie walking away. Everybody within earshot of that conversation. You heard people testify about what they heard about the knife.
Several of them
How
didn't say
you heard
that.
Keenan phrased it. He was going insane. He was pissed off about what happened, what had just happened to the car. You heard Dimitri. He was angry about what had happened to the car. Tyler De Silva, Jack Snyder. You heard Mackenzie say, "I heard somebody asking about a knife, but I don't know exactly who it was because she's walking away." Right.
She
So we
did
know
not
the knife
say
comes out at
that.
that point in time. He's angry. He arms
She
himself
didn't
with a
say
knife
that.
at that point. But then the Shelton kids come down the street after having just told them, "Get out of here, get the heck out of here." Now look, was it right that things were thrown at the car? 100% no. It was not right at all. Wasn't right that people were hitting the car, shaking the car, and people throwing things from the car at the kids or at the cars parked on the side of the street. That wasn't right either. But at that point in time, nobody called the police. They drove down the street. Could have called the police at that point. They said, "Hey, someone just damaged my car. I want to arrest for criminal mischief." They didn't do that. The defendant at that point in time thought it was very important to arm himself with a 3-inch bladed knife at that point. So the kids come down the street. You heard Tyler Rich, Charlie Connery, Ty Wood, Ricky Fiola, a few other kids go down the street. And yeah, there's things thrown at the car. They throw things back, right? But there's no physical altercation between the parties down the street. Because if there was going to be a physical altercation initiated by the Shelton kids, it would have happened right then and there, but it didn't. Right? Again, Tyler Rich running down the street. Get out of here. You guys got to get out of here. Now, you heard some testimony that somebody threw this can of WD-40 or PB Blaster back at Tyler Rich, and he's walking away. And at some point in time, he sees the defendant, and the defendant's walking towards him. So he sprays him to get him away. Ricky Fiola sees this. He's within a short distance to see this happening. At some point in time, Ricky Fiola approaches the defendant and has a conversation. And what did you hear him testify to? He said, listen, hey man, it's really messed up what he did. He shouldn't have persuaded you with that stuff. But look, there's a lot of us, and there's only 5 of you guys should probably just get out of here. And while he's having that conversation, what does Ricky Fiola see? Ricky Fiola sees the defendant holding a knife in his hand. Ricky Fiola turns around, walks back. The rest of the Shelton kids walk back to Tyler Rich's house. Again, no physical altercation down the road. Mackenzie Traficante is calling her sister, I need a ride home. At some point in time, Will, Dimitri, and Keenan get out of the car. And they don't want to be a part of anything. They want to ride home. They stay down the end of the street. Rides are being called. Will calls his girlfriend, come pick me up. I think you heard testimony from Mackenzie Traficante who said, no, Leo, just stay down here. Stay with me. Come home with me. That's not what he wanted to do. Because Ryan Hines, who he had just sucker punched in the head earlier that night and helmeted back at Lazy Brook, who was now at this party, now he wanted to go back and face those kids. But he wasn't going back, just him. He was going back with a knife. Because who else goes back to a house, right? I mean, you heard testimony when he was in the car with a bunch of other people, and the car was being shook and rocked and thrown at, that he was panicked, he was frightened, he was scared, he was terrified. If you're all those things, why are we not staying down the road? Why are we not waiting for Mackenzie's sisters to come pick us up? Why are we not calling somebody to come pick us up? Because he wasn't scared, terrified, panicked. It's simply not. That's not the case. He was mad. He was pissed. He was angry, and he had a knife. So they wanted to go back and go and confront those kids. Now there's some testimony that Tyler wanted to go talk about the damage, and he knows Tyler Rich. Maybe he could work something out. But the bottom line is, he's the one that was going ballistic about the car. Yeah, sure. Tyler and Snyder were angry, but he's going crazy, and he's the one that armed himself with a knife. So he gets back in that car. He makes the willful decision, right, to get back in that car, armed with a knife, and go back to the very house he was told to leave. But he would have you believe he was panicked, scared, frightened, all those things. So Jack pulls up to the 43 Laurel Glen. The defendant and Mr. De Silva get out. You've heard testimony from several witnesses that Tyler's on the left, the defendant's on the right. They move onto property. They were told to leave, so now they're trespassing. Some kids were outside. Got a little bigger when people heard, oh, people are here. You heard Tyler Rich say, I told him to get the F out of my property. The defendant walks up. Ryan Hines, Faison Teal, Tommy Connery somewhere behind them, but closer in proximity to the defendant. Ty Wood there is also there. And you heard Tyler Rich say, I was yelling at these kids, get the hell off my property. I looked out of the corner of my eye and I saw Raul cock his arm like he was going to punch Ty Wood. And that's when I just hold off and cracked him in the face. And it was on. So I would submit to you, if the defendant walked down the property, confronted those kids, and started to throw a punch or pretend like he was going to throw a punch, he was the initial aggressor in the altercation by coming back, by approaching those kids, and by cocking his arm. He was the initial aggressor. He provoked the fight and started the fight. He gets hit, it's on. All right, now I can claim self-defense. Now I can take this knife out that I have in my pocket while I'm on the ground, open it up, right? All intentional conduct, and start stabbing kids, right? You heard him testify, I was flailing my arms. I would submit to you, if you look at any of the injuries on these kids from 3 years ago, those are deliberate stab wounds. Those are not flailing slash marks. Stab wounds. So he stabs Ryan Hines 3 times. He stabs Faison Teal in the arm. Again, upper, right, left arm here, Hines up in the chest as he's working his way down. And Tommy Connery, you heard testimony from Tommy Connery, who comes over and he's trying to push him away. And he's on the ground. The defense on the ground. And he comes right after him and starts stabbing him in the leg 4 times. Deliberate. Again, what was his intent?
What was his intent? Please. Yes. What was his intent?
This wasn't self-defense. He went into that fight already armed. His response to this fight was unreasonable when you look at it in totality. It was a fist fight that escalated by his doing because he was the only one there with a weapon.
So a
Some point in
weapon
time,
is how you
the defendant
escalate it.
Goes
Got
back
it.
to the car that's waiting for him.
Got it.
He would have you believe he was chased. I would suggest to you that the video shows a different story. But nevertheless, he's back at the car, looks back, and wants to run back in. He purposefully runs back in with the knife. And you hear Charlie Connery yelling, he's got a knife, he's got a knife, he's got a knife. And there's another person there yelling, get out of here, bro. Because again, the Shelton kids didn't want them there. There was a communication to leave. Again, all of these things could have been prevented. This is Jimmy McGrath just before he gets stabbed at the end of the fight. He's not engaging the defendant, but he would have you believe that he or somebody else was, so that he can cloak himself with self-defense or defense of third parties. He had a duty to retreat and not even go after Jimmy McGrath. He was unarmed and he did nothing wrong. And even if you believe from the evidence that Jimmy was involved somewhere in the fight, somewhere, which there's been no evidence of that, but even if that's what you can infer from the video, I would submit to you that self-defense is not retaliatory. It's defensive. You can't come back and stab somebody just because you're mad. And that's exactly what happened here. He came back from the car. He ran back at people who were already, the fight was already done. Tyler De Silva clearly in the road. The fight was over. Kids were screaming back and forth. Tyler De Silva even said the fight was over at that point. You hear, get out of here, bro. And at the very end of the video, you see Jimmy McGrath step back like this to try to avoid the fight, the stab wound, the deliberate stab wound in his chest. He didn't stab him in the foot. He didn't stab him in the lower leg. He stabbed him right in the chest. What was his intent when he did that? When that happens, you hear Jimmy McGrath yell, "I've been stabbed," and he collapses. He collapses.
Yes, sir!
So he unnecessarily stabs Jimmy, right? You're gonna hear an instruction about intent, right? I'm sure the defense attorney's gonna get up here and argue, he didn't wake up that morning, want to kill anybody or stab anybody. It's not what intent's about. Intent can be formed in an instant. It can be formed within a moment. I would submit to you at the beginning of that fight that was not on video, as soon as he got hit, he informed the intent, the specific intent to stab people and cause serious physical injury, right? He went back to the car and he informed the same intent when he turned around and saw Jimmy. I'm going to stab this kid and get out of here. Why else would you stab him in the heart? You stab him right in the chest, piercing his heart. After he gets back to the car, he tells you that, or Snyder indicates, gets back in the car and he says, I just stabbed like 4 kids. So he knew how many kids he stabbed. He knew how many.
How could he
But
know
knew he stabbed
that?
kids. He got to understand here. I don't know if I stabbed him. Right? We heard that testimony. I don't know if I stabbed him. I was only one with the knife, but couldn't even say it. But he said it that night. He knew he stabbed kids that night. So we know he did it. They go back down the road. No, before we get there, they take off. De Silva jumps in the car. They take off. They take a left. They go down Adams Drive. They're at the cul-de-sac. He says, "Stop the car," and throws the knife into the woods. Why? Consciousness of guilt. There's instruction about consciousness of guilt. Why are we getting rid of the weapon? Right? Gets back in the car. Go, go, go. They go back down to 36 Laurel Glen. Mackenzie's sister's there. He tells Jack and Tyler, "I'm going home, Mackenzie." Jumps in the car with Mackenzie, and the cars leave the area. Mackenzie drops off Keenan and Dimitri, and then they subsequently drop off the defendant at his house. Mackenzie was mad, right? She told you, I was pissed. I didn't want to be there. I was mad at him. They were going there to fight. I didn't want to be there. I didn't want to be involved in any of that. They were all going there to fight that night.
She was done with him. Prom was
After the
over.
defendant gets dropped off, you hear about the text messages that go back and forth between Mackenzie, who was his then girlfriend, and Raul. And he's saying things like, I can't text anything. I wasn't there. You know I wasn't there. Nothing is happening. Don't text me. I'm going to Florida. I didn't do anything. That was text messaging. They didn't want to put anything in writing. You also hear that he spoke to Tyler De Silva on the phone. When he spoke to Tyler De Silva on the phone, he says, "Dude, I fucked up. I'm sorry. I don't know what to do." Because he knew what he was doing that night, and now he's having buyer's remorse. So again, what was his intent, right? You guys are really going to be able to examine what his intent was. And the judge is going to give you an instruction such as, there's no particular length of time necessary for the defendant to have formed the intent. Intent can be formed in an instant. It can be created in a moment. Intent may be, and usually is, inferred from the circumstances of the crime, since no witness can come into court and testify that they looked into a defendant's mind and saw what his intention was. You can look at the number of wounds inflicted, the location of those wounds on each person's body, the type of instrument used to cause those wounds, and his conduct during all of this. I would submit you can even look at the conduct from Lazy Brook. What was his conduct during that fight, and for what his intent was later on that night. In this case, the state contends that there were 9 stab wounds inflicted by this defendant on 4 different individuals. They were stab wounds, not slashes. I would suggest to you that a person who stabs multiple people multiple times in areas of the body that would cause serious physical injury and death intended to cause those serious physical injuries and death. There's no other rational conclusion. So that's what this case is about. The defendant was enraged about what had happened earlier. He armed himself and he returned to a house to face those kids with the intent to stab somebody. He could have waited down the street. He could have called the cops. He didn't have to go back. He did. He intentionally went back. It doesn't make sense when someone says, I was very scared, frightened, and panicked. to go put yourself back in that situation. It makes zero sense.
You don't understand loyalty,
And because
sir.
of his conduct, 3 people are going to have to live with scars for the rest of their lives, both mentally and physically. And James McGrath lost his life unnecessarily. And the ripple effects that's caused his family. The credible evidence in this case shows that on that day, he intentionally caused physical injury to Faison Teal. He caused that injury by stabbing him in the upper arm with a dangerous instrument. With regards to Tommy Connery, the credible evidence shows that he intentionally caused serious physical injury to Tommy Connery. He specifically intended to cause that injury by stabbing him 4 times in the upper leg, causing deep stab wounds. You heard testimony from his doctor. She was concerned about compartment syndrome and him losing his leg. Deep stab wounds. I mean, deep stab wounds. These are not flailing slash marks. These are deep stab wounds. Again, the manner in which the wounds are inflicted. It's not corroborative of slash marks. And he did that with a dangerous instrument. With regards to Ryan Hines, he intentionally caused serious physical injury to Ryan Hines. He had the specific intent to cause that injury by stabbing him 3 times in the upper torso, causing a collapsed lung and other injuries to his lower abdomen and hip area. And he did that again with the dangerous instrument. And with regards to Jimmy McGrath, he formed the specific intent to kill Jimmy McGrath at the moment he came back from that car, turned to him, and plunged the knife into his heart. He didn't slash at Jimmy McGrath. He plunged the knife into his heart, through his rib cage, and through his heart, and the poor kid bled to death right there on the front lawn.
Sir, pull yourself together.
You know,
This is the problem with this case. It's way too personal. Now it makes sense. Now it
the
makes
judge is going
sense.
to give you instruction on sympathy. You need to follow that instruction. And I apologize for getting a little choked up here, because I have a son as well.
So do I.
And I can't imagine what it feels like to have that happen. And I hope no one else ever has to. I hope no one else has to go through this ever. It's terrible. I apologize for
It is
taking a
terrible.
moment. But again, the judge is going to give you instruction on sympathy, so please follow that instruction on sympathy. But we are confident that after you review all this evidence, you will find the state has proved each and every element of the charge beyond reasonable doubt. You'll find that the defendant intentionally caused the death of Jimmy McGrath, intentionally caused assault in the first degree to both Ryan Hines and Tom Connery, and intentionally caused physical injury to Faison Teal with a dangerous instrument. We're confident after you review all the evidence, you'll determine this was not self-defense. He provoked this fight. He was the initial aggressor, and he had a duty to retreat, and he should have. The state urges you at this time, well, after you deliberate the evidence, we urge you that you find the defendant guilty of all the crimes charged and the information. The defense now have an opportunity to speak with you. And when he's finished, I'll come back and speak with you again. Thank you.
Exactly, Lauren. Please follow the instruction on sympathy, even though I'm not.
Good morning, everyone. Y'all are probably tired of seeing me come up here and set up with all my stuff, so I'll just get right into it. This might be a hard case because it involves young people. It might be difficult because it involves young people. Right? But it is not a complicated case. It is a case about the most basic right that any of us have, which is the right to defend ourselves when we're faced with people that are intent on doing us serious physical harm. It could be as much as death, serious disfigurement, and all the other things you're going to hear about that. You've heard from the state here telling you, I guess, that Raul Valle is a criminal mastermind who came over there with the plan to be able to use all of this so that now I can claim self-defense. You heard Mr. Valle get on the stand. Mr. Valle, a criminal mastermind, can put together a plan like that? And back home, we'd say, son, bless your heart, but that was mighty stupid. There was a whole lot of stupid to go around that night. There was a fire that got lit earlier in the night, and it started with all that drinking that was going on. And nobody there to say, what are we doing? How do we come into all of this? That's the first fire that was lit.
Yeah.
And there were a lot more along the way. Again, not a complicated case. Mr. Valle took the stand. He talked to you. He didn't have to do that. Mr. Valle used a 3-inch pocket knife that Jack Snyder gave him, that Jack Snyder brought, that Mr. Valle didn't even know existed prior to that night. Mr. Valle didn't even know existed prior to Mr. Snyder giving it to him. Where was Lito Valle seated when Jack Snyder pulled that knife out and had it on his lap? Was he in the front passenger seat?
Ah.
No. That was Tyler DeSilva. Lito Valle is behind him with Mackenzie Trafficante on his lap. There's no way he can see that knife in Jack Snyder's lap. And Jack Snyder's the one who told you he took that out and put it in his own lap because he was so scared about what was going on. So Lito Valle can't see that knife, doesn't know it exists. Mr. Snyder told you he didn't, there was no way that Mr. Valle could have known it was there before. He never brought it out. He never said to him, hey, I got this knife. Let's go riding over to 43 LGD and get a little payback. None of that happened. So it doesn't make any sense when Jack Snyder tells you that Lito Valle asked him for a knife that he didn't even know existed.
Excellent point.
Now I get it. Maybe some of you want to believe Jack Snyder and Tyler DeSilva. Maybe you say to yourself, gosh, those kids, nice looking kids, they get up here on the stand. Why shouldn't I believe them? Well, ask yourself, why should you believe them over Mr. Valle? Is there something about Mr. Valle and the way he came up here and took the stand and testified that tells you you should disbelieve him, but believe those two? I didn't hear the state talk at all about exhibits 94 and 96 when they were up here. Did you? What are exhibits 94 and 96? I bet you remember. I hope it weighed heavily on your mind. Imagine if I came up here and asked you to believe witnesses. I can't even call them paid witnesses. They have something more valuable than any money they could ever be given. What is more valuable than a complete immunity agreement? Anything?
Bingo.
Is there anything that an 18, 19, 20-year-old kid would not come up here and do or say in order to avoid any penalty whatsoever for their actions?
Any penalty.
Does that bother you? Does that disturb you?
Bothers
It
me.
should. Does that sound like justice for all? Does that sound like justice for some? Does that sound like equal justice to you? Going to give those two kids immunity agreements. Jack Snyder drove the car over there, gives the knife over to my client. Tyler DeSilva gets in that same car, rides over there to 43 Laurel Glen Drive, says he's going to go make peace. Listen, there was a lot of stupid going around that night. Tyler DeSilva got up here on the stand and told you, well, I thought I could go up and talk to them because I didn't have a problem with them.
The talker.
Maybe he did. Maybe some of you sitting here look at these kids and think of your own kids. State's attorney did. I know I did. Would any of you put your faith in something as important as this in a 16 or 17-year-old? Would you have reason to doubt that maybe they would fail to go to the grocery store and get everything that you had for them on the list? But we're going to sit here and expect these folks to give us the evidence that we need in order to convict somebody of murder who's charged with the same things that these folks could and should be charged with. They told you that. They know what they're exposed to. I went over it with them. I asked them about it. They know exactly what they're doing when they're coming in here. Jack Snyder's story doesn't make any sense. He gave him the knife because he asked for the knife that he didn't know existed. It's not just implausible. It's not just improbable. It is impossible. You don't ask for something that you don't know exists. He didn't know it existed before that moment.
Good point.
So we watched the ring video. The ring video is the 36 Laurel Glen Drive. That's exhibit 44. You'll have that available too. You see the car stop. You see Mackenzie get out. She's walking up ahead. Raul's already on the curb. A little shamed. In a bad situation here. Mackenzie's obviously upset with him. She's walking down towards the curb. Tyler DeSilva gets out of the front. And then the car stops. And it's there for some time before it drives off. And Mr. Valle told you that's when Jack Snyder threw him the knife and said, just in case. Just in case what? Just in case this situation that I caused over here at 43 Laurel Glen Drive comes running down the street at you, throwing things and hollering things, and I'm about to drive off and leave you?
Yeah.
Does that make more sense than, he was pissed off. He was the most pissed off. He was angrier than anybody else there. And he asked me for that knife that he didn't know existed. Jack Snyder has every incentive in the world to make these folks and you promises that he just can't deliver on. He's got there is no more powerful incentive in the whole world than what he's got. What are the terms of that agreement that he was given? He's got to come in here and testify truthfully. But who makes that determination? Who's he working for when he's under that immunity agreement? Not me, not you, the state. And what did they all tell you almost without fail about what they did before they came in here? They met with the state's attorney a number of times. To do what? To get ready, to make sure that when they took that stand, they were going to testify truthfully. And I put air quotes around that. Because what does truthfully mean in this instance? To those guys, as they told you, it meant not deviating from the things that they had said. The things that they waited 7 months and after they'd gotten an immunity agreement before they were going to say anything. Now, when we were in here during jury selection, some of you said, well, there can be a lot of gray. There's more than two sides to every story. That was a bit of truth. How many sides to a story did we get here?
A lot.
And some of you said, well, a lot of people will lie. And you said that maybe you had a little bit of an idea about what happened here. You've got way more of an idea now about what happened here. And some of you said, well, I don't expect everyone to testify truthfully. People may want to defend or protect their families. You need more than just common sense to determine credibility. Some of you said you had an experience with a kangaroo court. You know what that's like. Don't turn this into a kangaroo court by putting any more weight into the testimony of Tyler DeSilva and Jack Snyder than what it deserves. And it doesn't deserve any more weight than the paper and the ink on which it is written, because that incentive is overwhelming. That's more than just defending your friends or your family. That's defending yourself. And some of you said, if we don't follow the law, our system wouldn't work. It's not here just for one person. It's not here just for a few people. It's here for all of us. And that's right. We all take seats that were laid out for you hundreds of years ago. You come in and you take those seats. You got to put your sympathy aside. Sympathy for the victim, sympathy for the complainant, sympathy for anybody. It's got no place here. Some of you have experience taking things through a process, doing quality control and making sure that everything has been met along the way. Use that experience here. Does this make sense? Would this pass through quality control? I told you before, some of these witnesses, if not all of them, are promising more than they can deliver. Imagine if somebody tells you something that just can't be true. Somebody tells you they got to make a delivery and it's going to take them an hour and a half to get from here, in the middle of the day, through the city, down to DC in 3.5 hours. They're making you a promise because they want you to believe them. They know you'd be really happy if they could actually make that trip, but they can't deliver on that. That's more than what they could possibly do. That's what these witnesses are doing for you. They're telling you things that they can see that couldn't have been seen. Why are they doing that? They want to avoid consequences that Mr. Valle is now saddled with.
All those assumptions
They
I
want to
kept
protect
saying.
themselves. They want to protect their friends. And they want to protect the memory of a loved one that they lost. Now, during jury selection, I asked you all if you could be open to the idea of self-defense. And to a person, you told me that you could. Some of you said you'd had to use some self-defense before. And you said you'd be open to it and you could understand that the law allows you to use self-defense. Defend yourself, defend loved ones. Whether or not you had experience with doing that, you said you'd be open to it. I don't know what you thought you were going to hear or what you thought self-defense looked like. Some of you had experience with it, some of you don't. But this is what self-defense looks like. It's messy. It's chaotic. It transpires quickly, and you don't have to make the best decision. That's not what the law requires. That's not. It's a higher bar than anybody could be expected to make. It requires that you make a reasonable decision, that you make a decision that you had a reason for. You watch those videos, you know there's a reason for the defense that he used. He's down on the ground. He's getting kicked, stomped, punched, and he's being given no reason to believe that that's going to stop unless he makes it stop. Nobody's saying, that's enough, guys. Everybody up. Just a few licks and then we'll let him go. That didn't happen. What did happen? People joined in the fray. There were at least 15 to 20 people out there at a minimum. And you know that because if you watch that video, you can count them. Michael Sampieri, Sal Perry, Jacob Villalobos, Matthew Lockovich, Ryan Hines, Ty Wood, Tanner Chernowski, Tommy Connery, Charlie Connery. The list goes on. We heard about all of them. We see some of them. Alex Burnson. Some of them couldn't be identified. Those are at least the people that we can see. And Mr. Valle's down on the ground, getting kicked, punched, can't tell what's going on around him. Ryan Hines is on top of him. And Ryan Hines is punching him in the face. And Ryan Hines tells you, I didn't think he was aiming for me necessarily. Because he wasn't.
He
He
just wanted
reaches in his
out.
pocket and he takes out the only thing that he's got there. The only thing at that point that he thinks is going to make them stop because they've not given him any reason to believe that they're going to do so on their own. And maybe you're thinking to yourself, well, yeah, but he said he brought a knife to a fist fight. No, he didn't bring that knife to that fist fight. He had that knife in his pocket because Jack Snyder took it out and threw it to him. And he's got some kids running down the way. He picks it up, sticks it in his pocket. Now you heard the state argue to you, well, you know, they submit that that's when he gave it to him now, is when we see it on that ring video, agreeing, I guess, with what Mr. Valle tells us, which is in fact, as you will recall, entirely different than what Mr. Snyder says,
Oh, yeah.
than what Keenan Frasick says. Snyder tells you he doesn't give him the knife until it's asked for, which again is completely ridiculous and unbelievable. But he tells you that happens after they're looking at the car. After he's dropped them off, driven down the street, leading them there, comes back, and then everybody else who was still in the car gets out. Do you remember that? That was Jack Snyder's testimony. He didn't tell you that he threw it to them while they were right there. And Keenan Frasick, what does he describe? A mad scramble through the console, through the glove compartment. Where's that knife? Give me the fucking knife.
Right.
Didn't happen.
No.
It's just unbelievable. It's not what Jack Snyder or anybody else describes. But Jack Snyder and Tyler DaSilva and all these other kids that are in that car, all these kids that had once been his friends, all these kids who haven't talked to him ever since that night, though they still remain very close with one another.
Interestingly enough.
Those kids all told you that Mr. Valle was the most upset of anyone there. More upset than Jack Snyder about his car. More upset than Tyler DaSilva, who was worried about the damages and how much it was going to cost. He was the most upset of anybody there. And he went into a rage. He was so angry. I've never seen anybody that angry in my life. He goes digging through the car and this and that and the other. Why? Does that make any sense? Of course not. Not unless you start to think about what's motivating them to ostracize and distance themselves from Mr. Valle, to aggrandize what he was doing so they can demonize him, so they can wipe their hands at Mr. Valle. I have no idea. I don't know. He was so mad. He was so angry. I just thought we were just going to go get back in the car and I was going to go make peace. It doesn't make any sense. Mr. Valle told you he and Tyler DeSilva were best friends. Again, it might have been mighty stupid to get back in that car. But there was so much stupid running around that night. And now Mr. Valle's the only one sitting here facing anything for it. Because he got in that car and had a pocket knife in his pocket. You'll recall not a single witness telling you that he got out of that car and came onto that lawn with that knife displayed. None of them saw it. He didn't get out dancing around with it, licking the blade, asking who wants a piece of this. None of that. He's not a person who carries a knife. It wasn't his knife. And mind you, one of the charges that you don't hear here is criminal trespassing.
Good point.
It was stupid going on that lawn. I would agree with you. We could argue about that, and I would concede that. But it wasn't criminal under those circumstances. Those kids, for whatever their reasons were, had invited them there and wanted them on that lawn.
Yes.
What do they tell you? Did we hear a series of witnesses come in here and tell us all the things that they could remember so clearly? And they all could remember. I looked in the car. I might have been a long way away, but I could see Mr. Valle, and I could see Tyler DeSilva, and I could see Mackenzie Trafficante, and I could see there. But then when it came time to tell us, well, who else was there with you? Who else went out into the front yard with you? I can't really recall. Really? But you told us that all those folks were your friends, lifelong friends, grew up with them from childhood, been over to their homes, so comfortable that when they got to the house, they could walk right up and go in through the Bilko doors.
The Bilko doors.
That they could go downstairs, nobody would even blink an eye, right? And when they got down there, they could see their friends, they knew who was there. But then when they all went outside, do you remember this? It was everyone got up. All of us went together. Oh, really? Who were you beside? Ooh, I can't recall that, actually, now that you mention it. Oh, okay. Well, who was at the car? Some of them told you, there was a couple of us at the car, right? Maybe 3 or 4 of us at the car. Then others told you, no, there was maybe 10 of us that went to the car. And there were others that told you, no, there was more like 15 or 20 of us, and we were all around the car. Some of them told you, I didn't see anybody touch the car. I didn't see anything going on over there. It was peaceful, what I saw. And yet others told you, no, we had our hands on the car. We were rocking it. There was somebody bouncing up and down on the rear bumper. Who? I can't recall. Oh, okay, but you just went through a whole list of folks that could tell us were there, that you saw downstairs, and you all went out together. So surely you must have seen Tyler Rich by the car. I don't recall. Oh, okay. What about Ty Wood? Where was he? I don't recall. You will have the opportunity to see all the evidence here as long as you want, as many times as you wish. Do a test. Do an experiment. Go through those witnesses. See when they can't remember things and ask yourselves if that's convenient, if it seems like they're protecting their friends. Or ask yourselves, is there something wrong with their memories? Why is it so selective? Why can they remember some things but not others? And do those things seem designed to protect their friends and themselves? Okay. Tyler Rich has got to tell you that he told Tyler DeSilva to get the fuck out of here when he sees him on his lawn. Because what he can't come in here and tell you is he didn't tell him get the fuck out of here. He wanted him on that lawn. And he wanted for his friends and him to be able to jump them and get some payback. Because if he tells you that, and if he tells the cops that, then he and his friends could get charged. Maybe they get an immunity agreement. Who knows? But they certainly have to admit to some conduct that is criminal. And they're not going to do that. They didn't do it that night to the extent that they came in here and told you things that were different from what they told the cops before. I tried to point that out. I asked every single one of you during jury selection, probably looking at me like, what in the world is this all about? I gave you the parking lot example. Everybody remember the parking lot example? Right? I said, what would you be interested in knowing? Right? If you came out and you saw two strangers that you've never met before, and they're each pointing at each other and saying, he did it. And you look at your white car. Remember the white car? It's got a long red dash. Remember the red dash? I said, would you be interested in knowing whether either of them drove a red car? I was looking at you kind of like, I guess. I said, okay. Would you be interested in knowing whether or not there was any objective, other evidence that you could look at, like surveillance camera footage? He said, yes, that would be interesting to me. And I said, okay. Would you be interested in whether or not there were any eyewitnesses or people who claimed to be eyewitnesses? And you all said, yes, I think I would be interested in that. And I said, would you be further interested in knowing where those people were standing and whether or not it was possible for them to have seen what they claimed to have seen? And you all said, yes. And then I finalized that and I said, would you be interested in seeing how all of that evidence either aligns or doesn't? And you all said, yes. I know you did.
Good
because I wouldn't have
job.
chosen you otherwise. That's your job, is to look at that evidence. It's my job, based on what you told me, to try and show you those things about the evidence that gives you some doubt about what you're being told. You're being asked to align yourself with Tyler De Silva and Jack Snyder. You're being asked to condone that testimony and accept that and say, I don't have a reasonable doubt about what those two fellas told me. Again, would you trust those two fellas knowing that that had that kind of incentive under any other circumstances where you had a decision as serious as this to make? If they were the two guys, the paid spokespeople that were telling you about a surgery that you should get, would you want to know what sort of value they were being given to tell you that that was what you needed to do? Of course you would. Would you make a serious decision and not have a reasonable doubt about it on the basis of those two folks? Would you trust that kind of evidence under those circumstances? Of course you wouldn't. Don't start doing it now. Why would you? You'll never forgive yourself if you do that. Don't overlook your reasonable doubts. This system is built on reasonable doubt. It's fundamental because none of us were there. We're looking at it after the fact. We're trying to determine, has the state proven its case beyond a reasonable doubt? You may feel inclined to try and solve the crime or somehow make things right. That's not your job. You can't fix all the ills that led up to that night. Your job is to determine whether or not you have a reasonable doubt about what happened that evening based on the evidence that you've been presented. And I think you've got more than a single reasonable doubt. You've got reasons to doubt Jack Snyder. You've got reasons to doubt Tyler De Silva. And you should heed those doubts. That's what the law tells you to do. Listen to your doubt. Give your doubt credence. It is, in fact, what binds us because it's there for all of us. And if you don't follow that doubt and give it the credence that it deserves, you're not following the law. And you're leaving these seats in a lower place than they were there when you took them. Just as fundamental to our system is the presumption of innocence. And again, I know I asked every single one of you whether or not you could uphold that. Whether or not you could tell me as you sat there looking at Mr. Valle that you could presume him to be innocent, despite the fact that he had been charged with these things. And again, you know, we made it kind of easy for you. This is not a case of a whodunit. This is not a case where we're claiming somebody else, who knows? No, this is not a case about who did what. With the exception, perhaps, I guess, of Faison Teal, as I think about it. There's no evidence really to show you that what happened to Faison, cut on his arm there, was as a result of a stab any more than Faison coming in and getting in a couple stomps, somebody pushing him from behind, and him getting a cut there. There really isn't. But it's not about who had the knife. It's about why and whether or not that was reasonable. Did he have a reason to do that? Or was he just out there to kill somebody? The state gets a lot of things wrong about this case. But it got one thing absolutely right. This is a specific intent case. But it's not specific intent to murder. You know that. You sat here through all of this. There was no specific intent to go out and murder. In order to believe that there was specific intent to murder Jimmy McGrath, you would have to believe that Mr. Valle was some sort of trained knife fighter who knew that by taking a 3-inch pocket knife and inserting it between the 6th and 7th intercostal, that he could strike directly into Mr. McGrath's heart. Now again, he's no criminal mastermind, and he's certainly no trained knife fighter. What he was a 16-year-old boy down on the ground getting stomped and kicked. And the numbers were overwhelming. Was it 15? Was it 20? Were they all focusing their attention on him at one point? Were they all focusing their attention on Tyler Da Silva? In that chaos, that's not a determination he could or had to make. None of us likes violence. We're not up here saying violence is okay. That's not part of the argument. But what we're saying and what the law says is that when you have a reason to believe that you need to defend yourself, that you have a right to do that and to use the force necessary. And that's what he did. And how do you know that that's what he did? Well, I guess if the state's now conceding that he got that knife during that exchange down on 36 Laurel Glen Drive, when we see those folks coming up, then the state should also have to concede the following. He had that knife in his pocket, and he didn't take it out when those folks came up. And he didn't take it out when he got sprayed in the face with WD-40 or PB Blaster. Forgive me, I have no idea what PB Blaster is, but I understand it's something that you could spray out from an aerosol can. And he didn't use it then either, despite having it right in his pocket. That's a lot of control for a person that they want you to believe is basically a homicidal me. You can't be both. And when he's down on the ground, you may recall Ryan Hines telling you, again, I didn't feel like he was aiming at me. And what else did he tell you about his positioning? Do you remember? You can see his arm doing this thing, but it looked like his other arm, his bicep, somehow stuck under him or pinned beneath him. Sure, because he told you he was in the fetal position down on the ground before he was able to get that knife out and start using it. And he had not just Ryan Hines on him, but all those other boys. You can see it in the video. You've got a couple different versions of that video, and I gave you Defense Exhibit B, and I'd ask you to use it, a frame by frame that you can go through as fast, as slow, focus in on a single frame, and you can see that there are two groups that peel off, that there are two folks that are wearing very similar outfits, and those outfits look very much like the lighter bottoms, dark blue top, some graphic on the back, the Jimmy McGrath. And Tommy Connery admitted to having been wearing that. And you can see in some of those frames feet attached to those figures, kicking a figure down on the ground that is clearly not Tyler Da Silva because he's being subjected to a separate beating over to the left. And you heard about how there were two fights developed. That one goes down over to the right, and one's going on over to the left. And think about what he's facing at that moment when he's down on the ground, because that's what self-defense requires. Not us sitting here later in the cool hindsight of this room, the ability to say, this, that. No, it's at that moment when you're 16 years old and you're down on the ground and you're facing the entire Shelton High School football team that's pissed off and they already know about the fight at 5 Lazy Brook, right? You heard testimony. They got there and everybody was already asking them about it. One of the first persons that came up to ask Ryan Hines about it was Jimmy McGrath. Griffin Marcinzik told you, Jimmy McGrath's one of the toughest kids I knew. There was already a building fury in that basement. They didn't know about that. This bunch of idiots are in the car. They just got added to a group chat. People are talking shit to them, as they said. People that they claim they knew on social. Can we all agree that if you think you know somebody on social, you don't know that person? I think you guys have all gleaned what a Luddite I am by my inability to work this contraption over here. Knowing somebody on social, you just don't know anything about that person. These were all strangers, at least to my client. Now, you know they're not all strangers to Tyler Da Silva. He told you about growing up with some of them. He told you about they knew cousins and things of this nature. And here they are, texting in the group chat, talking shit. And he says, He thought it would be funny to tell them to come over to Trumbull High School because they were going to leave Trumbull High School. And if they showed up, they'd be gone. And then he told you, I saw a picture that got sent on the group chat, and I realized, oh man, I know some of these kids. And he left. He left the group chat. There's Tyler DeSilva, Jack Snyder in the front seat. They're still going back and forth. They're still going at it. Jack Snyder, Griffin Marcinzik are really going at it, right? Griffin Marcinzik is taking photos of the car out front saying sitting ducks. That's what he was facing when he's down on the ground. You and I coming up around him and saying, what's going on here, my friend? Perhaps you should not be here right now. This appears to be a bad idea. No, that's not what that video shows. And let's talk about the existence of that video.
Oh.
These kids were ready. They came out with their phones going. This was gonna be a trophy. Just like a hunter hanging a head up on the wall. Let's document this. Let's record this. Not, oh gosh, we don't want this to be going on. This seems a little too violent. Gentlemen, let the young man up. No, we're filming this thing. And we're celebrating. You remember Tanner Janowski up on that stand? When I asked him, can you identify whose voice that is saying, yes, sir?
Yes, sir.
That was me. That was you? And you're saying, yes, sir. Is that celebratory? I don't know what you mean. Celebratory. I don't know. I don't know why I said it. Oh, did somebody ask you a question to which the answer was yes, sir? Is that what happened? No, I don't think so. No, I don't think so either. And again, how many times did these guys tell you something here that they admitted they hadn't told anyone before? And how often were they telling you, we were all doing something? Everybody just went. I couldn't see this and that and the other. But then on cross-examination, they would tell you, oh, well, yeah, everyone was throwing something, but actually that was me that was throwing something. Everyone was screaming stuff, but actually that was me that was doing it. They wanted to minimize their involvement, generalize what they were doing, anonymize it, and scrub it clean. So they can come in here and tell you, we were just shocked to find this going on.
Shock and awe.
You know that's not true. If you want to believe that, ask yourselves, why? Why do you want to believe that? Sympathy? Do you have any reason not to doubt that when they tell you that? These are people that are filming a beating, not just one. Ricky Fiola's filming too, right? We just don't have that film.
Oh, disappeared.
Ricky Fiola's
Tricky
over
Ricky.
there. He's got the camera out. He's doing this. You can see him in these freeze frames that they show you, right? It's like this. And you can almost kind of see when he turns over and he looks at the camera and the light shines right in his eyes. The gets that little red. And he's kind of like, oh shit. Right? Oh, I didn't realize somebody else would be filming me filming. And then he goes, and what does he do with that? He goes and gives it right to the cops, right? No. He takes it and he shows it to some girls that were watching the thing go on. He wants to show them Tyler DeSilva getting beat because he thought one of the girls would like seeing Tyler get kind of drifted off. Right? And I asked him, can you finish that for us? And he couldn't remember what it was that he wanted to show him for that. There's no reason to believe that those folks were going to stop unless they were made to stop. And if you tell yourself that there's a reason to believe that they were going to stop unless they were made to stop, if somebody back in that jury room tells you, no, he didn't have to do that. They were just going to stop and then let him up. Well, what's the reason to believe that? I'm asking, what's the reason to believe that? What's the psychology of a mob? What's the psychology of 18 to 20 boys and men? Don't forget, this is a boy at that time. Some of those folks there were men. They had already graduated. Right? They told you. Taylor Capella told us. It was mostly older kids there that night. What is the psychology of a mob? The problem with the mob is not what they do as much as what they might do. Because you don't know what they might do. So when you're down on the ground, you're getting kicked and punched and stomped. And again, we know there's at least 15 to 20 people there. It doesn't matter what these witnesses got up here and told us on the stand as far as saying, no, it was just a one-on-one, or maybe it was two of them talking with them. That's just simply unbelievable based on what we see there and what's going on that video. And we heard a little bit from some of the witnesses trying to tell us Raul's there on the lawn beside Tyler DeSilva. They're facing this big group of Shelton High football players that have started to circle them. He's not got the knife out, but he's going to pull back like he's cocked and ready to punch somebody. And who was that supposed to be? Ty Woods? You didn't hear Ty Woods tell you that, did you? No. You didn't hear a thing from Ty Woods. You heard the people that are trying to protect themselves from what they did tell you that that's why Tyler Rich just had to haul off, even though he was over here talking to Tyler De Silva, and punch Mr. Valley, who again still had not pulled out a knife, even though he's got it in his pocket. Didn't even pull it out to say, "Hey, whoa, guys, this is looking a little dangerous here. I think maybe you should all know, back off." No, at that point, Tyler De Silva's still thinking he's going to make peace because he knows somebody's cousins. They know his cousins. Ricky Fiola and Tanner Chernowski are proof that everybody there knew what they were planning to do because they had their cameras ready to go. So those are the kind of folks that are kicking and stomping and punching Tyler De Silva, Mr. Valley, while they're down on the ground. And the first three folks that get stabbed, look at their wounds. Again, Faison Teal. He told you, well, I was sort of over on the side, and then I came in and I started getting in a few, what do you call them? Light stomps? Medium stomps? You ever been medium stomped? Anybody? What's a medium stomp? A stomp is a stomp. A stomp is somebody down on the ground. You don't stomp somebody who's standing up, do you? No. No more than you stab somebody in the legs, unless you're down on the ground.
Ooh, good point.
Look at those wounds. One to the back of the leg. A couple to the front.
That's a good point.
Those are wounds that you give somebody when you're down on the ground. You don't bend down and give a couple here and a little there and then we get one in the back. That's not how that happens. It happens fast because you're frightened and you're panicked and you're scared and you have a reason to believe that you've got to do that because nothing else is stopping them. In fact, you heard Mr. Valley. It scared him even more after he had to do that because it didn't stop. And you've got Ryan Hines. Look at his injuries. One to the ribs. What, when you're over top of him? When you're punching him in the face? Then further down on the side, and finally one down on the hip flank area. Again, what did he do? Mr. Valley was standing with him and went, one here, one here, one here, one there. It makes no sense. It's not the way this happened. It's not the way self-defense happens. Again, it's not complicated. Doesn't mean it's not hard. Doesn't mean it's not difficult. The decision that you have to make. But it is not complicated. It is simple. He's down on the ground. He's getting beat. He's getting stomped. The same thing is happening to his friend. Nothing is telling them that that's going to end unless he makes it stop. So with his arm pinned behind him while he's getting stomped and kicked, boom, Ryan Hines. Tommy Connery tells you he comes over and separates them, right? And he takes his place. Takes his place over top of him, pounding him on him? No, he's over there as well, getting in his kicks. His leg gets stuck, gets the side, the back, right? Now, Ryan Hines tells you after he got stabbed, that was it. He had nothing to do with what happened to Tyler De Silva. You know that's not true because you saw that video. You saw that green hoodie, black shorts with the white trim right over there on top of Tyler De Silva, kicking him and stomping him with the rest of the group. Part of the state's argument here is simple. Who are you going to believe? Our witnesses or your lying eyes? Look at the video. Watch it, and you will see there are two groups here. You will see one group breaks off. That's the group that is beating on Mr. Valley, and then you can see them shove him into the road. He walks to the car. Thank goodness, at that point, Tanner Chernowski was gone. Because what do we see? Camera pans over. He's looking. What's he looking at? He's looking at where Mr. Valley is. Mr. Valley's by the car. He opens the door briefly. You see the light come on inside, the interior light. And then you see his head go just like this. Right? And we can see the side of his face. We see the profile. And you can almost hear the wheels clicking inside Tanner Chernowski's mind. It's like, what's he looking at? You see the camera pan again. Boom. What does that camera pan right to? Tyler De Silva on the ground, surrounded, getting pounded on by a number of kids, right? Kids that are saying, yeah, come on, get some. Who wants a piece of this? Yes, sir. That's what's going on. Any indication those kids are going to just stop that at that point? No. Not a single reason to believe that they're going to stop. They didn't stop with my client until he had used that knife. And they gave him no reason to think that they were gonna until he used it. That knife was a tool. It was the only tool that he had available to him to survive that night. That was the specific intent that he had. States charge specific intent crimes. Again, they're right about specific intent, but it's not specific intent to murder. It's not specific intent to assault. It's specific intent to survive. Because he had no reason to believe they were going to just let him, that was going to stop. They were intent on pummeling him into unconsciousness at best, serious physical harm, almost certainly, and no way to know whether or not that was going to stop until he was dead. Just not. If you want to believe otherwise, ask yourself why. You're going to get an instruction on implicit bias. Is there something about the way my client looks, the way I am, that makes you think he's any less believable than those kids? That he deserves to have self-defense available to him any less than any one of us? That those kids, if they were down in that same position, wouldn't have done that exact same thing? Would it change your mind if he'd had a screwdriver with a 3-inch shaft in his pocket and that he pulled that out and used it?
Or a bat?
He had the same wounds, stabs and punctures. This is what self-defense looks like. Most of us have never had to think about that before, right? What does self-defense look like? I don't know. Maybe I saw it in a movie or something. There's no manual for self-defense. When you're down on the ground, there's no handbook that you can pull out and be like, page one, getting stomped by group of, how many of you are here? Okay. It doesn't work like that. The law doesn't require you to go through that. Because if it did, you'd be dead. Maybe that's something that you've never thought about with the law. But I asked you guys, I know I did. Can you follow the law even if you don't like it? And I probably gave you some ridiculous example, like have you ever heard the song, I Can't Drive 55? There's a guy who doesn't like the speed limit rules, and he says he can't follow them. Well, this is a lot more serious than that, right? This is, can you follow the law even if you don't like the fact that somebody died? But the law is, you just have to make a reasonable choice. Did he have a reason to do what he did? Yes. Do you have any reason to doubt that? What is it? Because Tyler Da Silva told you that the fight was over when he got back over there? You saw Tyler Da Silva in that video. He didn't think the fight was over. He's in the street, hitching up his pants, facing back towards the group. And we can't see Raul at that point. Tanner's perspective is over here. We can see Jimmy McGrath a little bit on the side. And you heard Mr. Valle tell you. They were forming a semicircle. They were forming a horseshoe. And I asked all of those witnesses who watched that video, where did those kids go? Where was Charlie Connery coming from? Followed by 1, 2, 3, 4, 5 kids. Who were those kids that were following him? One of them was Matthew Aldridge. One of them was Jimmy McGrath. Where were they coming from? Watch that video. Use the frame by frame. Go through that part closely. You'll see exactly where they were coming from. They're coming from just having been involved with the fight with Lito that shoved him out into the grass, out into the street. That's exactly where they're coming from. Now, he didn't have time to identify anybody. He didn't know Jimmy McGrath. That's probably the tragedy, the most tragic thing of this whole thing. These kids are practically strangers, at least when it comes to Mr. Valle. As to all of them. And with a stranger, you can't know. What is that person going to do? You have to make your decisions based on the information that they're giving you at that moment. And what's the information that he's got? These are kids that are going to attack the car. These are kids that are going to stomp, kick, punch, gang up on, film it, record it. For what? I asked Tanner Chernowski, why are you recording this? Oh, I don't know. I just do that. And then at some point he admitted to collect memories. He thought this was going to be a memory that he wanted to keep before he knew what the tragic outcome was. But when he thought it was just a beating and an assault that was going to go on, yeah, that was a memory he wanted to collect. That's who Tanner Chernowski is. That's who these other kids were. Now, some of you might be thinking, well, when he comes back onto the grass and he passes by Tyler Da Silva, at that point, I can't see any of those other kids that are there. I just see Tyler, and then I see a little bit of Jimmy. Well, you see a little bit more than that. You see that hand? Remember that hand down here around the back on Jimmy? It's not his hand. It's Matt Lockovich's hand. Because they're side by side. because they are part of a semi-surveillance. This is a group that has been acting as a group the entire time. You're telling me all of a sudden this group has decided, oh, let's split up, let's single out. No, in fact, you can see in the video across the way, there's another person on the other side of Mr. Valle. He's got on a dark top and there's some sort of white lettering across the top. You may remember I was trying to point that out. You're going to have that evidence. Take a look at it and ask yourself about perspective, right? Because when we're looking at things one way, we can see it like this, and these things appear to be very distant and far apart. But if I shift over here, now it looks like something else is in front. And ask yourself, wait a second. He steps into that place. These kids are all around him. They don't just disappear. And you say, okay, well, hold on. Charlie Connery's yelling, he's got a knife, he's got a knife. These kids are all backing up, right? Makes perfect sense, right? Thank you, Charlie. You solved that one for us.
I never heard
I
that.
think you did, inadvertently. Do you tell somebody who's running out of a house fire, fire, fire? I gotta warn you about the fire that you're running away from. No, you don't. You warn somebody about a danger that they are running into. And that's exactly what was happening here. He's got a knife, guys. Don't go rush him. You need to back up.
Very good point.
That's who you warn. You don't call off people that are already calling themselves off. Again, that just doesn't make sense.
Very, very good point.
And you don't have to believe those witnesses just because it's their friend who died. You don't. And you shouldn't. And you wouldn't under any other circumstances. Some of you have experience doing workplace investigations. You know this is way more serious. These stakes are so high. Why are you going to believe these witnesses and this evidence under circumstances like this, when you wouldn't believe these folks, knowing what you know about them, their selective memory, their efforts to minimize and generalize and anonymize, not put themselves or their friends in any danger? Lay it all on him. So your duty is to look at this situation, the circumstances that my client faced as they were at that time. It's at least 20 versus 2. It's at least that. Could have been more. Some of these folks told you, oh, well, there's people watching. They're just sitting. They're just watching. You want to believe that? There's probably nothing I can tell you or should even argue to you. These folks had sprayed WD-40 in his face. These folks, 20 versus 2. That's 40 fists, 40 feet and legs. There's nothing that says the force he uses to defend himself under those circumstances has got to be identical. Just because they have fists and feet doesn't mean he can only punch and kick back. That's not what self-defense requires. It simply requires reasonable. Is it reasonable to use a 3-inch pocket knife that you didn't bring, but that you have in your pocket because your friend gave it to you? Under those circumstances, of course it is. Look at these wounds. Jimmy McGrath, 1 wound. That's it. He's not trying to stab him over and over and over. He steps into this situation. Look at the amount of time between the time he steps onto the grass. And again, perspective. They want to try and tell you that that kid on the far side of him is not lined up with Mr. Valle. Look at the grass underneath their feet. Valle's on the grass. That kid's on the grass too. The line of the curve goes just like this. You know about horizon and perspective? They're almost side by side, those 2 kids. The other kids haven't gone anywhere. It's wet. You remember me asking all these kids, is it dark, wet, rainy, misty? I don't remember. You can see it in the video. You can see rain beating on the windows of the cars. Of course, it's
Coming
wet.
down.
Kurt Taylor DePella tell us he came onto the grass and he slipped. He spun around. Mr. Valle told you he got punched. Somebody swung at him. Did you see Matt Lokovich's hand on Jimmy's back? And all of a sudden it's gone. You can infer what happened there. Matt Lokovich takes a swing at him. And Mr. Valle tells you, I just swung. I put everything I had into it. I was terrified. These kids hadn't stopped before when they were stomping me and I had to use that. They weren't stopping now. Did he have a safe retreat that he could completely and safely retreat? Of course not. Last time that he had tried to get up, these kids tackled him and went down again. And here they were coming again. And we know they were coming again because we hear them being warned. He's got a knife. He's got a knife. Again, you're not telling that to somebody who's not walking towards that danger you're trying to walk him on. Who's not rushing towards that person once again. Mr. McGrath, He's holding the edge. These are all football players, right? They know what it means to hold the edge. He's holding the edge, that horseshoe, that's the circle. He's a threat just as much as anybody else in that mob at that point. Those are the circumstances that Mr. Valle was facing. That's what you have to judge him. If you want to believe these kids, look, you've heard about consciousness of guilt, right? Why have we heard this evidence about consciousness of guilt? It doesn't change anything about what happened down there on the ground at that point. It's just another effort to make my client look like some sort of criminal mastermind. He knew to go out and throw the knife into the woods. Well, let's talk about that. Who told us that that's what happened? Only one person. Jack Snyder.
Yep.
When he's in here singing for his supper, the jailhouse keys ringing in his ear, he's trying to give you something, trying to give the state something to believe him. Oh, I haven't found a knife. I'll tell him he threw the knife down at the end of Adams in the cul-de-sac. And then Shelton PD, Detective Bango tells you, oh, we went out, we looked for the knife, couldn't find it. No knife. I guess that means Jack Snyder must be true. I guess Jack Snyder must be telling us the truth now about this. Tyler Silva didn't tell you anything about that. He's in the car. It stops. Nearly hits his head on the back seat. He's screaming at Jack about something. 1 or 2 seconds later, Mr. Valle hops back in the car. Mr. Valle told you. I got out of the car. I was feeling some pain. I looked at my ribs. He didn't tell you that he had the knife or that he did something with it. He told you he lost that knife, right? And he told you he lost that knife as he was running back. He trips and falls. And what's he got on his hands? You've seen it. He's got 2 big, nasty strawberries on the heels, palms of his hands, exactly like somebody would have when they fell to the asphalt. Like it looks like road rash. And he lost the knife of that. Do you have any more reason to believe Jack Snyder about anything, let alone that? Of course not. Ask yourself, if you want to believe him, why? Why do I want to believe Jack Snyder so badly? He's not giving you any reason to believe him. The text messages. Again, here's my client, criminal mastermind, conscious of guilt. So he's texting with his girlfriend, who's also, no, she's 17. He's 16, she's 17. They're texting back and forth. Like he's going to convince her that he wasn't there. That doesn't make any sense. He was panicked. He was still scared. He had no idea what had just happened. Look what he'd just been through. He's not going to convince her that I wasn't there. And then he goes to Florida. He's 16. He doesn't go to Florida because he's trying to get away from things and he knows that he can go down there and escape. I don't even know if you can get on a flight when you're only 16 years old. But he gets on that flight because that's what his parents told him to do. And that's what you do when you're 16. And your parents tell you we're going to Florida.
That's what I said.
It's not a mastermind move on his part. It's just trying to make him look bad. He doesn't need any help looking bad. Okay? Again, bless his heart, there was a whole lot of stupid going around that night. That's my client that I'm talking about.
Bless his heart.
Mr. Valle is no different than any of these other kids. And if you're telling yourself for some reason that you think that he is, ask yourself why. Look at the situation all these kids were in that night. How did they get there? These kids at 43 Laurel Glen Drive were like torches. My client and his friends, they were like straw. Throw those torches in there, and put them all together. There's absolutely no way to know what is going to happen as that wildfire starts to catch and goes round on the front lawn of 43 Laurel Glen Drive. But he certainly knew as he was down on the ground that folks weren't stopping with the stomping. They weren't stopping with the kicking and the punching. And so he used that knife, a tool to survive. If you're down in the bottom of a hole, dirt's being shoved on top of you, you're going to use a shovel to climb your way out. That's what he was doing. You have every reason to believe that.
A little bit over, so we wrap it up.
Thank you, Hunter. Folks, I'm not going to apologize for taking up a little bit more time. I do want to thank you for listening. I hope you will look at that evidence. I hope you will take your time with it. I hope you will all understand this is probably the most important thing you've ever been asked to do in your lives. And I will tell you that the law requires you, despite the tragic ending in this case, the law requires you find my client not guilty. Thank you.
Okay, guys, I just have to say, I really liked how he wrapped everything up with that. And are y'all hearing the sighing? Are y'all hearing that? I feel like I'm watching flippin' Auntie Bev again. I'm fairly certain that's the prosecuting attorney. He's just, gross. Absolutely gross. All right. KS Granny, Melissa, Jay Cornish, yes, fantastic. I thought he was riveting to listen to as he kind of led us through things. Let's see what the rebuttal is going to be now.
Yeah, I'm going to go ahead and take a quick break before we can move on with this argument. So we'll stand in recess until 12:15. We'll come back at 12:15. I would invite you to stay back up to
Thank you. Good afternoon. This is my second opportunity to address all of you. It's funny that I'm listening to counsel's argument about there's a lot of Tyler DeSilva, Jack Snyder. This case does not rise and fall with Tyler DeSilva and Jack Snyder. The warrant was signed, you heard from Detective Bango, on Monday the 16th. So the warrant was signed. There was enough probable cause at that point. The investigation was still unfolding. But there was enough to arrest the defendant when he did that. Tyler DeSilva and Jack Snyder approached us 6 months later because they had information. And they want you to discredit everything that Tyler DeSilva and Jack Snyder said. But you have to look at it. Remember when Frank Wadier, I asked all of you, how do you determine credibility? Are you just going to sit there and look at here, you listen to what they have to say, what's their demeanor? But isn't it, use your common sense? How does what one witness say, how does it marry up to other witnesses' testimony in the entire case? Tyler DeSilva and Jack Snyder are not the only people that heard the defendant ask for the knife. Keenan Frasick did, Demetrius Arfanis did, Mackenzie Trafficati heard somebody ask him for a knife while she's walking away. There are other people that heard these things.
That's not
So
what they
again,
said.
Whether or not you're ready to just discredit them because they have an immunity agreement with the state of Connecticut, I suggest to you, see how the information they provided to you in this case marries up with the rest of the case.
He stepped
And I
in
would
it
agree
with
the
the
defense
little
that
video.
there was a lot of stupidity that night. Absolutely. But the bottom line is you can't bring a knife to a fist fight. You just can't. Look at the defendant's injuries days after the incident. He's not completely beat up. It's because he took the knife out immediately and started stabbing people. You would think he would have huge contusions all over his head, and he didn't even go to the hospital. I would submit if he was that badly beat up, and the only way out was just I could not. I had to fight for my life. But the physical evidence does not show that. And there was testimony. His arms pinned under his body. How did he get the knife out with one hand and open it up with one hand? I would submit that's next to impossible unless you're a pro at it. I think the more likely thing that you can infer from what happened is that he took the knife out of his pocket while he was involved in the fight. Immediately opened it up and started stabbing people. He wasn't on the ground like they would have you believe. He went after Tommy Connery. He stabbed Ryan Hines in the chest.
I'm in
It's just not
bizarro
reasonable to
world.
bring a knife to a fist fight. He went there looking for trouble. That's the bottom line. Because if he doesn't go back, none of this happens. But he went back. Imagine if he didn't go back with a knife, it would have just been a fist fight. That's all. But he went back with a weapon. You can't use more force than what's being used against you. And the defense would have you believe that being punched is deadly force. It's just simply not true.
What?
By the
Nobody
way,
gets beat to
they want you
death?
to discredit everybody that has testified in this case. This is not a whodunit, and they agree it's not a whodunit, right? He used the defense attorney used that parking lot example. I was actually thinking about this during the break. You know, the kids that testified, they saw what happened, right? It was chaotic, but they saw what happened. And when they go and they give a statement to the police, you know, were they asked who was to the right of you, who was to the left of you? Probably not. Did they know at the time? Maybe. But now it's 3 years later, right? So it's kind of like a situation where you're in a parking lot, you park your car. Now, all of you came here, you parked your car. Did you look to the right? Did you notice what color the car was next to you? Maybe some of you did. Maybe some of you didn't. But you know you parked next to a car, right?
If I
Now
parked next
imagine
to my
what
friend's car,
happens
I'd
when
know.
You see somebody being chased in the parking lot and get stabbed with a knife, right? Now that's a horrific event that you just witnessed. And you give a statement to the police, right? and you see, you're not going to say something like park next to the red car. Maybe you remember that at the time. So now fast forward 3 years later, I guarantee each and every one of you would recall that horrific event happening. But if you got on the stand and I said, well, what color was the car to the right of you? You can't recall. What color was the car to the left of you? I can't recall. Do you know if there were cars next to you? Yeah, I know there were cars next to me. I just don't recall what color. So the reality is the color of the car or the person that was standing next to anybody necessarily in and around that area, in this fight, this chaotic scene, is that important in the grand scheme of things, right? Does it make a fact and evidence more or less? Probably not, right? Because listen, there were a lot of people around, a lot of people were watching. There was 2 or 3 kids fighting at any given time, right? We've seen that. We've seen the video. But does it really make a difference if, Taylor Capella told she was standing next to who? Michaela Holt, right? She remembered her. Maybe there was somebody else next to her. She can't recall. Tommy Connery was standing in the driveway at any given time when the car first arrived. Yeah, I knew I was there. I was talking to people. I just can't remember exactly who I was talking to. But does that really matter in the grand scheme of things when we know the car arrived at 43 Laurel Way?
That's not what the issue is, sir.
The car was shook. The car was hit, and they took off. And according to people inside the car, it was scary. We didn't want to be there. We wanted to get out of there. And the defendant told you that. Again, assess his credibility, because when he's down the street, he arms himself with a knife and comes back. If you're really that scared, why would you go back and confront 30 kids who just shook the car? I mean, that makes no sense to me.
Because Tyler's a talker. He's going to talk them all
So, I mean, look,
into peace.
the defendant was angry. We don't know why he was angry. It's because of the car. We've heard testimony about that. It's because these kids really messed up the car, and he was pissed off, and it was almost like they one up them. He had already had one up on Ryan Hines back in Lazy Brook because he tuned him up with the helmet after he sucker punched him from behind. But now that they disrespected Jack Snyder's car, let's go back. Let's go back. If things go sideways, guess what? I got a plan B. That was the plan.
Sir.
Might have been a stupid plan, but that's what happened. That's the bottom line.
He was
This is
that
not
good a
something that
friend of
happened,
Jack's.
I mean, I would say instantaneously. As soon as he gets hit, he takes the knife on. He's not waiting to get pounded on. There's no way. If he was getting pounded on the way the defense suggested he would have more injuries that we would have seen after the fact. And he simply did not. And by the way, the defendant testified when he was running out of there after he stabbed McGrath in the chest, he dropped the knife. The cops looked for the knife all in that area. They couldn't find the knife. They actually walked up and down the street. They held the area. They looked for the knife the next day. No knife. And the information that Jack Snyder and Tyler DeSilva gave us, right? We didn't know where the knife came from. We knew the defendant had a knife. We didn't know how he had the knife or where it came from. Jack Snyder gave us that information. He came to us. We didn't go to him.
7 months later.
But even if you take DeSilva and Snyder out of it, it's still the defendant going back to 43 Laurel Way with a knife. There were people in his car that he went to high school with that heard him ask for a knife. He went there. He got out of the car. He went in and provoked the fight and instigated the fight. And it started. He took it out and started stabbing kids because that's what he wanted to do. And then once he was able to get out of there, he went back in for more. And they have to have you believe that he was being approached or surrounded when he came back into the fold. He has a duty to retreat. You can't come back into a fist fight with a knife. It's just not reasonable. It's not reasonable. Even if you believe that self-defense applies to the first 3 kids that are stabbed, even if you believe that, it certainly does not apply to Mr. McGrath. Because again, self-defense is not retaliatory. It's not punitive. It's defensive. You can't do things like this and then turn around and claim self-defense. He came back from the car. Charlie yelled, "He's got a knife." And within seconds, he turned around and stabbed McGrath in the chest. They want to have you believe that he slipped. He slipped. It was a purposeful stab in the chest, right? So again, when we're talking about intent, specific intent, the areas where the wounds were inflicted, right? The number of wounds inflicted, the defendant's manner and how he conducted himself that night, both at Lazy Brook and later that night, he did not have to go back to that house. It's as simple as that. He did not have to go back.
I agree with
He
that.
was going back with a plan B. That's as simple as that. And that conduct cannot be excused. It's a horrific event. It's terrible. It's a tragedy. That cannot happen, because if that happens all the time, then this is a very different world we live in.
Yeah, maybe you shouldn't get in a fist fight because somebody might have a
When I asked
knife
him on a cross-examination,
or a
you got out of
gun.
there and you left and you went home. After you texted Mackenzie, you didn't call the cops at that point, did you? Nope. You went to Florida, right? Yep. Did you call the cops when you're in Florida? Nope. After you learned the severity of the situation, did you call the cops and tell them, "Hey, this is what happened. I was pummeled. I was acting in self-defense"? Nope. So again, I would submit to you that, yeah, he knew what he was doing. As soon as he stabbed those kids, he told Jack, and they got out there and they went down to Adams Drive and got rid of the knife. Why are we getting rid of the knife? Call the cops. This just happened. It's horrific, but this is what got rid of the knife, got rid of the evidence. Tells his girlfriend, "I wasn't there, didn't want to put anything in writing, God forbid." So he said, "Yeah, you know what? I was really getting pummeled. I had to stab those kids to get out of there. I was really fighting for my life." Didn't say that in the text. Just said, "No, I wasn't there. It wasn't me. I don't know what you're talking about. I wasn't there." And then he told Tyler DeSilva subsequent to that he messed up. He knew. You know, the judge is going to give you, you know, the self-defense instruction. And again, it's only justified when a person reasonably believes that such force is necessary. Reasonably believes. The first thing he didn't do is he didn't punch back. He didn't kick. Grab that knife.
You don't know that, sir. Facts, not in
Again,
evidence.
you're going to hear the judge instruct that a person must not use more force than he reasonably believes is necessary. I would submit on that night he used more force than was reasonably necessary. And I state submits that we've proven that beyond a reasonable doubt. We also submit that he provoked the fight. You're going to hear some disqualifiers. If you believe the state has proven the disqualifiers, one or all of them, doesn't matter. If you believe we've proven those disqualifiers beyond a reasonable doubt, then he cannot avail himself of the self-defense claim. So in a provocation, you're going to hear the judge instruct that a circumstance under which a person is not justified in using any degree of physical force in self-defense against another person is when he provokes the other person to use physical force against him. The defendant must have specifically intended to provoke another into using physical force and then use force to defend himself from the ensuing force that he provoked that person to use against him. You're also going to hear about the initial aggressor. The instruction that with regards to that is another circumstance under which a person is not justified in using any degree of physical force in self-defense against another is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using physical force. He also has a duty to retreat. You're going to be instructed that two conditions must be met. A complete safe retreat is available to him, and he knows he can avoid the necessity of using deadly physical force, by making a complete safe retreat. Self-defense cannot be retaliatory. It must be defensive. It's not punitive. You know,
Is he going to cry again?
Again, if you look at if you look at everybody's testimony, they would need you to disbelieve everybody's testimony in this case.
We kind of disbelieve a lot of it.
If you looked at Jack Snyder and Tyler Silva, took them out of it and just listened to everybody else testified, I would submit that there is more than enough evidence to determine that this defendant brought a knife to a house he shouldn't have been at. And he used that knife. He shouldn't have. And after he used it, he went back in and he stabbed McGrath for no good reason. But I would submit that he formed the intent to kill him when he turned to him and lunged at him and stabbed him in the chest. You heard the testimony of the doctors, of the medical examiner. These were not slash wounds. These were puncture wounds, purposeful puncture wounds. You know, the fight lasted about 30 seconds. You heard evidence of that, 17 of which it was video recorded. I know defense counsel wants to point out that McGrath was involved in some of it. Unclear. You're the judges of that. But even if he was, like I said before in my opening remarks, self-defense cannot be retaliatory. Can't come back and say, well, listen, man, you were pushing me into the road. Sorry, I'm going to stab you. You can't do that. I mean, what kind of world do we live in? You know, yeah, it's not right that there's fist fights. It happens. But, I mean, look, Tyler DeSilva was getting beat up, but he wasn't getting completely demolished. I mean, at some point, they threw him out in the street and they said, get out of here. It was over.
I don't think Tyler felt that way.
Ryan Hines, Faison Teal, Tommy Conner, they came in and they told you what their part was in the whole situation, right?
Oh, we know all about him.
There's no self-defense claim against him. He was trying to get in there and breaking things up, pushing him away. Why did he deserve to get stabbed? And I would submit Ryan Hines. Yeah, Ryan Hines said, I hit him, punched him a couple times, but that's his fist. It's not a knife. If Ryan Hines had a weapon, it would be a different story. If Faison Teal had a weapon, this would be a different story. If Tommy Connery had a weapon, this would be a different story. And if Jimmy McGrath had a weapon, this would have been a different story. But the bottom line is you can't escalate the fight. And that's exactly what the defendant did.
Do y'all believe that? Tell me in the chat whether you agree with that or not.
Counsel indicated on his closing argument that Tyler Rich wanted him on the lawn. That's simply not true. And we have evidence of that down at 36 Laurel Glen. They ran down there. They're arguing back and forth. Things are being thrown, but there's no physical altercation. Why would you? Hey, let's wait and see if they come back. Let's fight on the lawn. I mean, just have the fight down the street. They didn't fight down the street. That's the whole point. They wanted them out of here.
No, I think they went back to talk about all the damage to the vehicle. I do believe that part.
Again, the judge is going to instruct you on what specific intent is. And no, there's no time, no particular time necessary, no length of time necessary to form the intent. I know, counsel, did he wake up in the morning? Yeah, I'm going to go kill somebody, stab his kids? Of course not. Of course not. But if that were the case, if we had to prove that somebody woke up in the morning saying, I'm going to go stab people or shoot people or kill people, then we would never be able to prosecute anybody.
Sir, defense counsel never said
And that's the
anything
point,
of the
because
sort.
it's the conduct at the time that it happens, right? That's how you can infer what his intent was. He created a specific intent when he decided to take out that knife and escalate the fight and stab him.
I think so too, Free Kelsey. The sheer number kind of outweighs the idea of them having weapons or not. This is an argument
You heard
that I
everybody
have
testify.
had.
I think I asked every person that testified that, when you were involved in the fight, did you have a weapon? What did you witness about the fight? Did you see anybody with weapons? Nobody had weapons there. It was a high school fight. A high school fight that the defendant escalated. And the interesting thing is, defense counsel didn't really spend much time on Taylor Capella and Charlie Connor. Those are the two individuals that actually saw the defendant stab McGrath, right? Turn to McGrath and lunge at him. Who was Charlie standing next to? Do you think Charlie wasn't? A lot of these kids, there were kids at the time. Their memories maybe have faded a bit. I don't recall exactly where, Tommy, Ricky Field was at any particular time.
Sir, we had Mr. I don't recall.
But the story is the same. The
Ryan
horrific event
Hines.
that's etched in their minds forever is the same.
Mm-mm-mm.
They recall this defendant who had no right to be there come back to that house and stab 4 of their friends. This is not about protecting people. They got to understand, yeah, we were underage drinking. Yeah, there was a fight. People were punching people and it wasn't right. Sure. But who were they protecting?
Their
Who are they
parents.
They just came in here and told their story from their perspective. And does it mean that because one person's perspective as to where they were standing or who they were standing with, and the other person doesn't remember them standing next to that person, does that mean that it's a lie, as the defense would have you believe? I would submit no. Because if you don't recall sitting next to each other a year from now, but you recall me arguing to you and the defense attorney arguing to you, that's all that matters, right? Because it's what you're perceiving here, not really in your periphery necessarily. And you may remember it, but does that matter is the question. Does it matter who was standing next to you at any particular time? And the defense attorney wants you to ask yourself, does a lot of it make sense? And the thing that I would submit to you that doesn't make any sense at all is if you were truly, truly scared of the 10 to 12 to 15 to 20 kids that just rocked the car and threw stuff at the car, if you were panicked, why would you go back and want to confront them? At the end of the day, that makes 0 sense. It makes 0 sense unless you had some courage in you, and you had some courage in you because you had a weapon. That's the only reason that would make sense. Because he went there, he had the intent to hurt somebody there, especially if the fight got physical. They want you to believe that the knife was the only tool that he could use to survive. I mean, he's not in the Amazon. This is a high school fight, this fight. That wouldn't have happened, by the way, if he didn't go back.
Well, there were lots of
No one
reasons
could
why it
seriously
didn't have to
injure
happen.
Orion, Faison, Tommy, and Jimmy. He didn't get seriously injured.
They could have stayed in the
You
house
can't bring a
too.
weapon to a fist fight. You just can't do it. And to excuse this conduct would be just wouldn't be right. Self-defense cannot be punitive. It has to be defensive. At the end of the day, that's what this case is about. And that's what they'll hang on their hat on. They want you to find self-defense. Because they can't hide around the fact that the defendant brought a knife. That's in a nutshell, that's what it is.
I don't
So,
get how that is.
You have a tough job, absolutely, because you have to look at every element of the charge. The state proved it beyond a reasonable doubt. We proved specific intent to cause serious physical injury with a weapon with regards to Hines and Tommy Connery. Did we prove the specific intent to cause physical injury with a weapon for Faison Teal? And did we prove that the defendant had the specific intent to kill Jimmy McGrath and cause his death? I submit to you that if you look at the conduct of the defendant, bringing that knife back, he could have left the knife in the car. He could have not taken the knife from Jack. Think about that. But he didn't do that. He brought the knife with him. If you look at that conduct and you're questioning, well, what was his intent? I mean, you have the Lacebrook fight too. Didn't need to helmet Hines, but he did. He helmeted the kid and then got up there and told you a different story. I think after you look at all the evidence in this case, cold, hard look at the facts, we're confident that you're going to find the defendant guilty of the murder of Jimmy McGrath, assault in the first degree for Ryan Hines, assault in the first degree for Tommy Connery, assault in the second degree for Faye Santia. Thank you very much for your time.
Thank you.
Okay. I need to breathe a little bit here because that man makes my blood pressure skyrocket. And one of the things I wanted to discuss, I wrote a couple notes here. He kept saying over and over again, and I have heard others, men, say this also. You don't bring a knife to a fist fight. You don't bring a knife to a fist fight. Don't bring a knife to a fist fight. Okay. But happened to be watching the news this morning, and an individual happened to storm out of his home waving a machete at a law enforcement individual, and the law enforcement officer shot and killed this man. He shot him 4 times. So do I then say you can't take a gun with a person that has a machete? Like, what are we talking about here? It's bizarre to me. It's like there's some code about fights, and I don't get the code. Like, you don't get in a fight because you don't know what the other person has. You know, maybe Raul had a knife and the other kid had a flippin' gun. You don't know. Ay. Breathe through it, Janet. Breathe through it. Breathe through it, girl. And exactly, Melissa. You always hear don't take a knife to a gunfight. Yeah, don't take your fists to a knife fight either. Exactly. 30 people to 2. I'd say that saying doesn't compute. I agree. These are all points that I struggle with. All right, let's see if I can find, this would have been what, day 10, jury instructions. Let's see if I can find something. Aha! They took a lunch break and came back for jury instructions. And let me see. Ooh, this was long jury instructions. Okay. That's all right. We got this. I'm going to put jury instructions probably on 1 1/4, just so that we can, but I'll keep the closed captions on so y'all can see what's being said. Let me get us queued up here. All right. Let me close caption us. Here we go.
Instructions. So I am going to instruct you on the law that is to apply to the faction you find in this case. You will have a copy of the court jury charge with you during the deliberations. This is going to be rather lengthy, so I do intend to give you a break during the course of my charge so that you can get up, stretch, use facilities, and sort of, get comfortable and be seated again for some period of time. So you have heard the evidence presented in this case. I am now going to instruct you as to the law that you are to apply in this case. During these instructions, I will, for the most part, be reading from prepared material. I do this so that I do not inadvertently give you incorrect instructions. So if I lose eye contact with you from time to time, please bear with me. The reading of these instructions, like I said earlier, is going to take some time. The function of the court and jury. It is exclusively the function of the court to state the rules of law that govern the case with instructions as to how you are to apply them. It is your obligation to accept the law as I stated. What I tell you, not what the attorneys tell you, is the law that you are to follow. If the law, as I give you, differs in any way from the claims of law made by counsel, dismiss from your minds what counsel have said to the extent it differs from what I tell you. You must follow all my instructions and not single out some and ignore others. They are all equally important. Also to note, in these instructions, the court does use the terms first count and count 1, second count and count 2, third count and count 3, fourth count and count 4, crimes and offenses and information and substitute information interchangeably. You as jurors are the sole judges of the facts. It is your duty to find the facts. You are entitled in the course of evaluating the evidence to draw any and all inferences that you find reasonable and logical from the evidence you hear. You are to recollect and weigh the evidence and form your own conclusions as to what the ultimate facts are. You may not go outside the courtroom or the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or suspicion, and you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathy. You should not be influenced by my actions during the trial in ruling on motions or objections by counsel, or in comments to counsel, or in questions to witnesses, or in setting forth the law in these instructions. You are not to take my actions as any indication of my opinion as to how you should determine the questions of fact. If I ask any questions of witnesses, you must not assume that I hold an opinion on the matter to which my questions may relate. Remember that you, as jurors, are at liberty to disregard all comments or questions of the court and the witnesses' responses to those questions in arriving at your own findings of the facts. You must not take anything I said or did during the trial as indicating what I think the evidence or what your verdict should be. Any reference I make to the evidence is only for the purpose of clarification of some point of law or a point of illustration, or to refresh your recollection as a general nature of the testimony. I do not intend to emphasize any evidence I mention or limit your consideration to it. If I do not mention certain evidence, you will use the evidence from your recollection. If my recollection of the evidence does not comport with your recollection, then it is the recollection which must prevail because you are the exclusive trier of the facts. The defendant justly relies upon you to consider carefully his claims, to consider carefully all the evidence, and to find him not guilty if the facts and the law require such a verdict. The defendant rightfully expects fair and just treatment at your hands. At the same time, the state of Connecticut and its people look to you to render a verdict of guilty if the facts and the law require such a verdict. The law prohibits the state's attorney or defense counsel from giving personal opinions as to whether the defendant is guilty or not guilty. During my instructions to you, I may repeat certain instructions. I apologize in advance. I do this for the purpose of organization. You are not to consider a repeated instruction more important than any other instruction. All instructions are equally important. Also, during my instructions, I may refer you to previous or subsequent instructions given. When I do this, I will identify it for you and direct you to the section to which I am referring. If there is an inconsistency in the number and the title of an instruction to which you are referred, it is the title of the instruction that shall be controlling in my reference to it. Presumption of innocence. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. This presumption of innocence is with the defendant when he was first presented for trial in this case. It continues with him throughout the trial unless and until such time as all evidence produced here and the orderly conduct of the case, considered in the light of these instructions of law and deliberated upon you in the jury room, satisfies you beyond a reasonable doubt that he is guilty. The presumption of innocence as to each crime charge and as to any lesser included offense as instructed by the court may be overcome only after the state introduces evidence that establishes the defendant's guilt beyond a reasonable doubt. If and when the presumption of innocence has been overcome by evidence proving beyond a reasonable doubt that the accused is guilty of a crime charge or any applicable lesser included offense as instructed by the court, then it is the sworn duty of the jury to enforce the law and render a guilty verdict. Burden of proof. The state has the burden of proving that the defendant is guilty of the crimes with which he is charged or a lesser included offense as instructed by the court. The defendant does not have to prove his innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute a crime charge or lesser included offense as instructed. Whether the burden of proof resting upon the state is sustained depends not on the number of witnesses nor on the quantity of testimony, but on the nature and quality of the testimony. Please bear in mind that one witness's testimony is sufficient to convict if it establishes all the elements of a crime beyond a reasonable doubt. Reasonable doubt. The meaning of reasonable doubt can be arrived at by emphasizing the word reasonable. It is not a surmise, a guess, or mere conjecture. It is not a doubt raised by anyone simply for the sake of raising a doubt. It is such a doubt as in serious affairs that concern you, you would heed. That is, such a doubt as would cause reasonable men and women to hesitate to act upon it in matters of importance. It is not hesitation springing from any feelings of pity or sympathy for the accused or any other person who might be affected by your decision. It is, in other words, a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that, after hearing all the evidence, If there is something in the evidence or lack of evidence that leaves in your mind, as reasonable men and women, a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and acquitted. Proof beyond a reasonable doubt is proof that precludes every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion. Evidence. The evidence from which you are to decide what the facts are consists of 1. The sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. 2. The exhibits that have been received into evidence as full exhibits, including any pictures, videos, or documents that have been marked as full exhibits. 3. Any facts that the court judicially noticed. And 4. Any stipulation of the parties. In reaching your verdict, you should consider all the testimony and full exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include 1. Arguments, statements, and questions by lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but it is not evidence. Likewise, any emotion, reenactment, or other actions displayed by counsel during this trial is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in the case or to appeal to your emotions. Also, attorneys have a duty to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it, and you are not to hold it against any party for making objections. During the course of the trial, you may have heard counsel stand up and make comments about questions made by opposing counsel. You are not to regard any comments that counsel may have made in your deliberations. Any comments on the propriety of questions are not proper for trial or your consideration and should not be used in your deliberations. Lastly, the questions the lawyers ask of witnesses are not evidence. It is the testimony of the witnesses in response to the attorney's questions that is evidence. 2. Testimony that has been excluded or stricken. If I have excluded certain testimony, you must follow my instructions to disregard the testimony. In effect, I'm telling you to do what may be difficult, but which you will have to do your best to accomplish, and that is to accept in your minds that such stricken testimony is not evidence and must not be considered in your deliberations. 3. Anything you may have seen or heard when the court was not in session. 4. Anything you may have seen or heard from any spectators during the trial. 5. The document called the substitute information, which you will have with you at the time of your deliberations. The information is merely the formal manner of accusing a person of a crime to bring that person to trial. You must not consider the amended information as any evidence of the guilt of the defendant or draw any inference of guilt because he has been charged with crimes. You will note that each count in the information contains within it the alleged date and location of the offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of each offense, including identification of the defendant, beyond a reasonable doubt. Direct and circumstantial evidence. There are generally two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, evidence from which you could find that another fact exists, even though it has not been proved directly. There is no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any particular evidence. Circumstantial evidence of an event is the testimony of witnesses as to the existence of certain facts or evidence or the happening of other events from which you may logically conclude that the event in question did happen. By way of example, let us assume that it is a December night and you're preparing to retire for the evening. You look out the window and you see it is snowing. You wake up the next morning, come to court, and testify that the night before it was snowing in the area of your house. That is direct evidence of the fact that it snowed the night before. You saw it and you came to court and testified to that fact. Now assume that it is another December night, the weather is clear, there is no snow on the ground, and you retire for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come into court and you testify to those facts. The evidence that the night before there was no snow on the ground and the next morning there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that sometime during the night it snowed and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is determine the believability of the direct testimony given, the credibility of the witness. With circumstantial evidence, you must first determine the credibility of the witness or witnesses and decide whether the facts testified to did exist. Then you must decide whether the happenings of those events or the existence of those facts leads logically to the conclusion that other events occurred or other facts exist, and ultimately whether the crimes alleged were committed by the accused. There is no reason to be prejudiced against evidence simply because it is circumstantial evidence. You make decisions based on circumstantial evidence in the everyday affairs of life. There is no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof by circumstantial evidence may be as conclusive as would be the testimony of witnesses speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of another fact or set of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in light of reason, experience, and common sense. Redacted exhibits. If there are exhibits that have been accepted into evidence as redacted versions of the original, please note that these redactions were made by way of agreement by counsel or by order of the court, and you must not speculate as to why the information was redacted or what was redacted. Redacted information is not evidence, and as indicated earlier, you may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or speculation. Credibility. In deciding what the facts are, you must consider all the evidence. In doing this, you must decide which testimony to believe and which testimony not to believe. You may believe all, none, or any part of any witness's testimony. In making that decision, you may consider a number of factors, including the following. 1. Was the witness able to see or hear or know the things about which that witness testified? 2. How well was the witness able to recall and describe those things? 3. What was the witness's manner while testifying? 4. Did the witness have an interest in the outcome of this case or any bias or prejudice concerning any party or any matter involved in the case? 5. How reasonable was the witness's testimony considered in light of all the evidence in this case? And 6. Was the witness's testimony contradicted by what that witness has said or done at another time, or by the testimony of other witnesses, or by other evidence? If you think that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely upon any of that witness's testimony. In deciding whether to believe a witness, keep in mind that people sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent lapse of memory or an intentional falsehood. And that may depend on whether that contradiction has to do with an important fact or with only a small detail. These are some of the factors you may consider in deciding whether to believe testimony. The weight of the evidence presented does not depend on the number of witnesses. It is the quality of the evidence, not the quantity of the evidence, that you must consider. Witness with a cooperation agreement. You have heard evidence that witnesses Jack Snyder and Tyler De Silva have signed a document entitled Cooperation Agreement with the state, the terms of which are contained in States Exhibit 94 and 96, respectively. These agreements are permissible, and the rules of court provide for their use. Although the state is permitted to present the testimony of someone who has signed a cooperation agreement in exchange for his testimony, you must examine the testimony of such a witness who provides evidence against a defendant with greater care and caution than the testimony of an ordinary witness. While examining the testimony of a witness who has signed a cooperation agreement and who has not been prosecuted with offenses for which the state has evidence, you should keep in mind that he may, in his own mind, be looking or hoping for some favorable treatment in the disposition of his own matters, and therefore may have such an interest in the outcome of this case that his testimony may have been colored by that fact. In considering the testimony of such a witness, you may consider whether there was any motive developed in the evidence for testifying falsely in inculpating the accused. The factors you may consider, among others, when evaluating the credibility of such a witness include the extent to which the witness's testimony is confirmed by other evidence, the specificity of the testimony, the extent to which the testimony contains details known only by the perpetrator of the alleged offense, the extent to which the details of the testimony could be obtained from a source other than the defendant, the circumstances under which the witness initially provided information supporting such testimony to law enforcement or a prosecutorial official, whether the witness has received a benefit or expects to receive a benefit, including immunity from prosecution, leniency in prosecution, leniency in sentencing, or personal advantage in exchange for testimony, and whether the witness has ever changed his testimony. Further, notwithstanding any language contained in Exhibits 94 and 96, the cooperation agreement signed by Jack Snyder and Tyler De Silva, respectively, it is your exclusive role to determine the credibility and believability of that witness. In other words, you and you alone are to determine whether any evidence offered by Jack Snyder or Tyler De Silva is to be believed wholly, partly, or not at all, irrespective of any language in the cooperation agreement that may suggest otherwise. The determination as to whether the state has proven the elements of the crimes charged beyond a reasonable doubt rests solely with the jury after a careful examination of all the evidence presented. You should carefully scrutinize the testimony of Jack Snyder and Tyler De Silva before you accept it. However, you are not required to disbelieve a witness because he has signed a cooperation agreement. The law recognizes that there are many offenses that are of such character that the only persons capable of giving useful testimony are those who are themselves implicated in the crime. Like all other questions of credibility, this is a question for you to determine based on all the evidence presented to you. It is your duty to decide what credibility to give to any witness. Therefore, it is your duty to decide whether Jack Snyder and Tyler De Silva are to be believed wholly, partly, or not at all. Testimony of police officials. Police officials have testified in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall the police official's demeanor on the stand and manner of testifying, and weigh and balance just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official just because he or she is a police official. Expert testimony. In this case, certain witnesses have taken the stand, given their qualifications, and testified as expert witnesses. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which the testimony relates. An expert is permitted not only to testify to facts that he or she personally observed, but also to state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion on them. An expert witness may state an opinion in response to a hypothetical question. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by an expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find that the facts assumed were proved and whether the facts relied on in reaching the opinion were complete or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. In this case, you were provided expert testimony by the following witnesses: Dr. James Gill, Dr. Ryan Doss, PA Eric Black, and Dr. Roselle Crombie. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to you to assist you in your deliberations. No such testimony is binding upon you, and you may disregard the testimony, either in whole or in part. It is for you to consider the testimony with the other circumstances in the case and, using your best judgment, determine whether you will give any weight to it, and if so, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitle it to receive, and it must be considered by you, but it is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. Defendant's testimony. In this case, the defendant testified. An accused person having testified stands before you just like any other witness. He is entitled to the same considerations and must have his testimony tested and measured by you by the same factors and standards as you would judge the testimony of any other witness. You have no right to disregard the defendant's testimony or to disbelieve the defendant's testimony merely because he is accused of committing multiple crimes. Consider my earlier instruction on the general subject matter of credibility and apply them to the defendant's testimony. Proximate cause. Proximate cause does not necessarily mean the last act or cause or the act and point in time nearest to the death or injuries. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though his acts will not be immediate cause of the death or injuries. An act or omission to act is a proximate cause of the death or injuries when it substantially and materially contributes in a natural and continuous sequence unbroken by an efficient intervening cause to the death or injuries. It is a cause without which the death or injuries would not have occurred. It is a predominating cause, a substantial factor from which the death or injuries follow as a natural, direct, and immediate consequence. It does not matter whether the particular kind of harm that results from the defendant's act be intended by the defendant. When the result is a foreseeable and natural result of the defendant's conduct, the law considers the chain of legal causation unbroken and holds the defendant criminally responsible. Specific intent. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. The concept of specific intent applies to count 1, murder and manslaughter in the first degree intentional as a lesser included offense, count 2, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense, count 3, assault in the first degree intentional and assault in the second degree intentional as a lesser included offense, and count 4, assault in the second degree intentional. Recklessness. person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when the defendant is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstance exists. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. The standard of conduct of a reasonable person in the same situation as the defendant is the doing of something that a reasonably prudent person would do under the circumstances, or omitting to do what a reasonably prudent person would not do under the circumstances. A gross deviation is a great or substantial deviation, not just a slight or moderate deviation. There must be a great or substantial difference between, on the one hand, the defendant's conduct in disregarding a substantial and unjustifiable risk, and on the other hand, what a reasonable person would have done under the circumstances. Whether a risk is substantial and unjustifiable is a question of fact for you to determine under all the circumstances. The concept of recklessness applies to count 1, manslaughter in the first degree, reckless as a lesser included offense, count 2, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. Count 3, assault in the first degree, reckless as a lesser included offense, and assault in the second degree, reckless as a lesser included offense. And count 4, assault in the second degree, reckless as a lesser included offense. Evidence of intent. What a person's intention was is usually a matter to be determined by inference. No person can testify that he or she looked into another's mind and saw therein a certain knowledge or a certain purpose or intention to do harm to another. Because direct evidence of the defendant's state of mind is rarely available, intent is generally proved by circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that, infer what his or her intention was. To draw such an inference is the proper function of a jury, provided, of course, that the inference drawn complies with the standards for inferences as explained in connection with my instruction on circumstantial evidence. The inference is not a necessary one. You are not required to infer a particular intent from the defendant's conduct or statements, but it is an inference that you may draw if you find that it is reasonable and logical. I remind you again, the burden of proving intent beyond a reasonable doubt is on the state. Evidence of motive, or the lack of it, may also be considered by you in determining the issue of intent. You will refer to the court's instruction on motive below. Motive. The law does not require that the state in a criminal case prove a motive because it is not an element of a crime. It is not necessary for the state to prove what reason the defendant may have had for committing a crime charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of a defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. Consciousness of guilt. In any criminal trial, it is permissible for the state to show that conduct or statements made by a defendant after the time of the alleged offense may have been influenced by the criminal act. That is, the conduct or statements show a consciousness of guilt. For example, flight and unexplained may indicate consciousness of guilt if the facts and circumstances support it. Such acts, however, do not raise a presumption of guilt. If you find the evidence proved and also find that the acts were influenced by the criminal act and not by any other reason, you may but are not required to infer from this evidence that the defendant was acting from a guilty conscience. The state claims that the following conduct is evidence of consciousness of guilt: the defendant's disposing of the knife, the defendant's denial of his involvement in text messages to his girlfriend, and the defendant's flight from the jurisdiction of Florida. It is up to you as judges of the facts to decide whether the defendant's acts, if proved, reflect a consciousness of guilt, and to consider such in your deliberations in conformity with these instructions. Identification of the defendant.
Interesting.
The state has the burden to not only prove every element of a crime, but also the identity of the defendant as the perpetrator of the crime. You must be satisfied beyond a reasonable doubt of the identity of the defendant as the one who committed the crime, or you must find the defendant not guilty. If you have a reasonable doubt as to the accuracy of the identification, you must find the defendant not guilty. Specific charges brought by the state. I will now turn to the specific offenses charged in this case. The substitute information in this case contains 4 counts against the defendant. In other words, the state charges the defendant with committing 4 separate offenses or crimes. You are to consider only the specific charges submitted to you and not concern yourself with how the information may have read when it was read to you at the start of trial. Please note, You will also be instructed to consider lesser included offenses where applicable. Additional instructions on your consideration of lesser included offenses will be provided further along in this charge as it concerns your deliberations on each count. The defendant is entitled to and must be given by you a separate and independent determination of whether he is guilty or not guilty as to each crime charged in each count, including lesser included offenses, if applicable, as instructed in accordance with this charge. Each of the 4 counts charged in the information, including lesser included offenses where applicable, sets forth a separate and distinct crime. The state is required to prove each element of each crime charged in a count, including lesser included offenses, beyond a reasonable doubt. Each crime charged under each count, including lesser included offenses where applicable, must be deliberated upon separately. Please note, the total number of counts charged in the information does not add to the strength of the state's case. You may find that some evidence applies to more than one count in the information or more than one crime under a count. The evidence, however, must be considered separately as to each element of each crime deliberated upon. Each count is a separate entity. You must consider each count separately, including lesser included offenses as instructed, and return a separate verdict for each count. This means that you may reach opposite verdicts on the 4 different counts. A decision on one count does not bind your decision on any other count. I have previously instructed you and herein reiterate. The substitute information is not evidence, it's merely a paper statement of charges against the defendant, on which the state proceeds to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt of the defendant from the substitute information. You will first deliberate on count 1, and then follow the order of deliberations as provided by the court in these instructions. So you're going to proceed to the court's instruction on count 1, murder. Statutory title, which is immediately below. 1, count 1, murder. Connecticut General Statutes, Section 53A, 54A, subsection A. The state charges the defendant in count 1 with murder, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the said Raul Valle with intent to cause the death of one James McGrath, did stab and cause the death of the said James McGrath in violation of Section 53A-54A, subsection A, of the Connecticut General Statutes. The statute defining the offense of murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person. For you to find the defendant guilty of this charge, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, intent to cause. The first element is that the defendant specifically intended to cause the death of James McGrath. There is no particular length of time necessary for the defendant to have formed the specific intent to kill James McGrath. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Murder is a specific intent crime, and you will refer to the court's earlier instruction on specific intent. The intent to cause death may be inferred from circumstantial evidence. You will refer to the court's earlier instruction on direct and circumstantial evidence. The type and number of wounds inflicted, as well as the instrument used, may be considered as evidence of the perpetrator's intent, and from such evidence an inference may be drawn that there was an intent to cause death. Any inference that may be drawn from the nature of the instrumentality used and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with my previous instructions. Such inferences are not necessary, but they are inferences you may draw if you find they are reasonable and logical and in accordance with my instructions on circumstantial evidence. Declarations and conduct of the accused before or after the infliction of wounds may be considered if you find they tend to show the defendant's intent. This inference is not a necessary one, that is, you are not required to infer intent from the defendant's alleged conduct, but it is an inference you may draw if you find it reasonable and logical and in accordance with my instructions on circumstantial evidence. Element 2, cause of death. Second element is that the defendant, acting with the intent to cause the death of James McGrath, caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of James McGrath's death. I'm going to refer to the court's earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, for the crime of murder, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause the death of James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the offense of murder, you shall find the defendant not guilty of the crime of murder and shall then next move on to consider lesser included offenses to murder below in the manner and order therein instructed therein. Proceed to the court's instruction on lesser included offenses to murder below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of murder, you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense and defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved beyond a reasonable doubt one of the statutory disqualifications, you shall reject the defenses and find the defendant guilty of murder in violation of Connecticut General Statute, Section 53A-54A, subsection A, at count 1. Please note, the state in proving statutory disqualifications has to prove the statutory disqualifications also beyond a reasonable doubt. This will enter deliberations on count 1. You will not deliberate lesser included offenses to murder. You will now deliberate on count 2. We'll skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault in the first degree intentional below. If, however, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of murder at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will enter deliberations on count 1. You will now deliberate on lesser included offenses to murder. You will now deliberate on count 2. You will skip over the court's instruction on lesser included offenses to murder and proceed directly to the court's instruction on count 2, assault in the first degree intentional below. Lesser included offenses to murder. In accordance with the court's previous instructions, you will consider lesser included offenses to murder under this section if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of murder and therefore have found the defendant not guilty of murder. The defendant at count 1, the substitute information, is specifically charged with the crime of murder. The offense of murder under our penal code is such that it may include the elements of the crimes of manslaughter in the first degree intentional and manslaughter in the first degree reckless. This brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to murder in the order and under the circumstances set forth herein. The fact that I am instructing you on lesser included offenses should not be interpreted by you that I believe the evidence proved the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case, and you must determine whether the defendant is guilty beyond a reasonable doubt of murder at count 1 or is guilty of any respective lesser included offense. You will first consider the lesser included offense of manslaughter in the first degree intentional, Connecticut General Statute, Section 53A, 55A1, directly below at subsection A. You proceed to the court's instruction, subsection A, manslaughter in the first degree intentional, the statutory reference directly below. Subsection A, manslaughter in the first degree intentional, Connecticut General Statute, Section 53A, 55A1. Statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when, with intent to cause serious physical injury to another person, he causes the death of such person. For the defendant to be found guilty of this charge, the state must prove the following two elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant specifically intended to cause serious physical injury to another person. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. You will note that the basis of the charge under this statute is not that the defendant intended to kill, but that he intended to inflict serious physical injury. A person acts intentionally with respect to a result when its conscious objective is to cause such result. Refer to the court's earlier instruction on specific intent at 15. The intent to cause serious physical injury may be inferred from circumstantial evidence. Refer to the court's earlier instruction on evidence of intent at 17. Element 2, cause death. The second element is that the defendant, acting with the intent to cause serious physical injury to a person, caused the death of a person. This means that the defendant's conduct was the proximate cause of the decedent's death. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause serious physical injury to James McGrath, and 2, in accordance with that intent, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, you shall find the defendant not guilty of manslaughter in the first degree intentional at count 1, and you shall next consider the lesser included offense of manslaughter in the first degree reckless. Proceed to the court's instruction B, manslaughter in the first degree reckless, Connecticut General Statute, Section 53A, 55A3 below. If, however, you unanimously find the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree intentional, you shall not consider any additional lesser included offense. You shall, however, consider the defendant's claims of self-defense and defense of others. refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree, intentional, in violation of Connecticut General Statute, Section 53A, 55A1 at count 1. This will end your deliberations at count 1. You will next deliberate on count 2. Proceed to the court's instruction. Count 2, assault in the first degree, intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree, intentional, in violation of Connecticut General Statutes 53A, 55A1 at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 1. You will not consider any additional lesser included offenses to murder. You shall skip over the court's instructions at subsection B below and next deliberate on count 2. B, manslaughter in the first degree, reckless, Connecticut General Statutes 53A, 55A3. You will deliberate on this lesser included offense to murder if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of murder, and therefore you have found the defendant not guilty of murder. And further, you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of manslaughter in the first degree intentional, and therefore you have found the defendant not guilty of manslaughter in the first degree intentional. The statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. For the defendant to be found guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a grave risk of death. The first element is that the defendant engaged in conduct that created a grave risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant's conduct demonstrated an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. Then element 4, cause of death. The fourth element is that the defendant's conduct caused the death of James McGrath. This means that the defendant's conduct was the proximate cause of the decedent's death. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that James McGrath died as a result of the actions of the defendant. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a grave risk of death. 2, the defendant acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, the defendant caused the death of James McGrath. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree reckless, you shall find the defendant not guilty of manslaughter in the first degree reckless at count 1. This ends your deliberations at count 1. You shall next move on to deliberate on count 2. And proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statute 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 at count 1. This will end your deliberations at count 1. You shall move on to deliberate on count 2. Proceed to the court's instruction on count 2, assault, first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, after considering the defenses, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of manslaughter in the first degree reckless at count 1, even though you have found the elements of that crime proven beyond a reasonable doubt. This will enter deliberations at count 1. You shall move on to deliberate on count 2. You'll proceed to my instruction on count 2, assault in first degree intentional, Connecticut General Statute, section 53A-59A1 below. All right, I'm going to give you a few minutes to stand up and stretch. We're going to take a short break. Some going to take a 10-minute break right now, give you some time to go back into the deliberations. And again, you can't talk in the middle of the charge. You're not allowed to. Thank you.
I'm getting us there, y'all. Stay with me. Are y'all learning? Because I've been taking some pretty good notes here. So I feel like I'm learning a lot about what the jury has to, what decisions they have to come to.
Welcome back, ladies and gentlemen of the jury. I want to thank you for your patience during the reading of these instructions. I know that it's a long time to be seated, so thank you for your attention. Counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, thank you so much. I'm going to continue. So I'll be continuing with count 2. Assault in the first degree intentional, Connecticut General Statutes 53A, 59A1. State charges the defendant at count 2 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant with intent to cause serious physical injury to one Ryan Hines did cause serious physical injury to the said Ryan Hines with a dangerous instrument, to wit, a knife, in violation of section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when, with intent to cause serious physical injury to another person, he causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. The first element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We refer to the court's earlier instruction on specific intent. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by a statute as physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss of impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Ryan Hines. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's earlier instruction on proximate cause. We must find it proved beyond a reasonable doubt that Ryan Hines was seriously injured as a result of the actions of the defendant. It does not matter whether Ryan Hines was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person, and that he in fact caused serious physical injury to that person or to some other person. Element 3, with a dangerous instrument. Third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it was used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstance. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person, the defendant did cause serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in first degree intentional at count 2, and shall move on to consider lesser included offenses to assault in the first degree intentional below. In the manner and order prescribed therein. You will proceed to the court's instruction on lesser included offenses to assault in first degree intentional under the section below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in first degree intentional, you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 23. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, then you shall reject the defenses and find the defendant guilty of assault in first degree intentional in violation of Connecticut General Statutes 53A, 59A1 at count 2. This will end your deliberations at count 2. You will not consider lesser included offenses. You will move on to deliberate count 3. So you'll skip over lesser included offenses to assault in the first degree intentional below. You proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defense alone, you shall find the defendant not guilty of assault in the first degree intentional at count 2. Even though you have found the elements of the crime of assault in the first degree intentional proved beyond a reasonable doubt. This will end your deliberations as to count 2. You shall then move on to deliberate count 3. You will skip the court's instruction on lesser included offenses to assault in the first degree intentional below, and proceed directly to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 2 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional at count 2. The defendant at count 2 information is specifically charged with the crime of assault in first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree, both intentional and reckless. This brings into play a rule of law known as lesser included offenses at count 2 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 2 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 2 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offenses. You, the jury, are the sole judges of the facts of this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below. Proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 directly below. A, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of this charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result of circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. The third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused serious physical injury. The fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proof beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death. 2, he acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, he caused serious physical injury to Ryan Hines. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 2, and you shall then consider the lesser included offense of assault in the second degree intentional. You'll proceed to the court's instruction on B, assault in second degree intentional, Connecticut General Statutes 53A, 60A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, Then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 at count 2. This will enter deliberations at count 2. You shall not consider any other lesser included offense at count 2. You will skip the court's instructions in subsections B and C below and shall next move on to deliberate on count 3. We'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will enter deliberations at count 2. You shall not consider any other lesser included defenses at count 2, included offenses at count 2. You will skip the court's instructions as subsections B and C below. You will move on to deliberate on count 3. You'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A, 59A1 below. Still under lesser included offenses, B, assault in the second degree intentional, Connecticut General Statutes 53A, 60A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 2. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove beyond a reasonable doubt 3 elements. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. You will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Element 2, cause physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. You will refer to the court's previous instruction on proximate cause at 14. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or to some other person. Element 3, the dangerous instrument. Third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person. 2, the defendant did cause physical injury to Ryan Hines. And 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 2, and you shall then consider the lesser included offense of assault in the second degree reckless. You'll proceed to my instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A, 60A3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. You will refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree, intentional, in violation of Connecticut General Statutes 53A 60A2 at count 2. This will end your deliberations at count 2. You shall not deliberate on any other lesser included offenses. You shall move on to deliberate count 3. Proceed to the court's instruction on count 3, assault in the first degree, intentional, Connecticut General Statutes 53A 59A A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, and on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree, intentional at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 2. You shall not consider any other lesser included offenses at count 2. You shall then move on to deliberate count 3. You will skip subsection C below and proceed to the court's instruction on count 3, assault in the first degree, intentional, Connecticut General Statutes 53A 59A1 below. Still on lesser included defenses, C, assault in second degree, reckless, Connecticut General Statute 53A 68.3. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the second degree intentional, and therefore have found the defendant not guilty of assault in the second degree intentional. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that this defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. Refer to my previous instruction on recklessness at 16. Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Ryan Hines was injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as a physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing a serious physical injury to another. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Ryan Hines, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 2. This will end your deliberations at count 2. You shall next move on to deliberate on count 3. Proceed to the court's instruction, count 3, assault in the first degree intentional, Connecticut General Statute, section 53A, 59A1 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statute, section 53A 68.3 at count 2. This will end your deliberations on count 2, and you shall move on to deliberate on count 3. You'll proceed to the court's instruction on count 3, assault in the first degree intentional, Connecticut General Statutes 53A 59A1 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt. Then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 2, even though you have found the elements of that crime proven beyond a reasonable doubt. This will enter deliberations at count 2. You shall move on to deliberate at count 3. Proceed to the court's instructions. Count 3, assault in the first degree intentional. Connecticut General Statutes 53A, 59A1 below. Count 3, assault in the first degree intentional. Connecticut General Statutes 53A, 59A1. The state charged the defendant in count 3 with assault in the first degree, charging that in the county of Fairfield, city of Shelton, on or about the 14th day of May 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause serious physical injury to one Thomas Connery Jr., did cause serious physical injury to the said Thomas Connery Jr. with a dangerous instrument, to wit a knife, in violation of section 53A, 59A1 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when with intent to cause serious physical injury to another person. He causes such injury to such person or to a third person by means of a dangerous instrument. For you to find the defendant guilty of his charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause serious physical injury. First element is that the defendant intended to cause serious physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such a result. Refer to my earlier instruction on specific intent at 15. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Element 2, cause serious physical injury. The second element is that acting with that intent, the defendant caused serious physical injury to Thomas Connery Jr. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to my earlier instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was seriously injured as a result of the actions of the defendant. It does not matter whether Thomas Connery Jr. was the person upon whom the defendant intended to inflict serious physical injury. It is sufficient if you find that the defendant intended to cause serious physical injury to another person and that he in fact caused serious physical injury to that person or to some other person. And element 3, with a dangerous weapon or instrument. The third element is that the defendant caused that injury by means of a dangerous instrument. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had that potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person. 2, the defendant did cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. I'm sorry. I'm going to strike the in summary that I just gave. Let me just read through that again. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause serious physical injury to another person. 2, the defendant did cause serious physical injury to Thomas Connery Jr. And 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree intentional, you shall find the defendant not guilty of the crime of assault in the first degree intentional at count 3. And you shall next consider the lesser included offenses, starting with assault in the first degree reckless, proceed to the court's instruction on lesser included offenses to assault in the first degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree intentional in violation of Connecticut General Statutes 53A-59A1 at count 3. This will enter deliberations at count 3. You will not consider lesser included offenses. You will move on to deliberate on count 4. Skip the court's instruction below on lesser included offenses to assault in the first degree intentional and proceed directly to the court's instructions on count 4, Assault and second degree intentional, Connecticut General Statutes 53A 68(2) below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you shall find the defendant not guilty of assault in the first degree intentional at count 3, even though you have found the elements of the crime of assault in the first degree intentional proof beyond a reasonable doubt. This will end your deliberations as to count 3. You will not consider lesser included offenses. You shall move on to deliberate on count 4. Skip the court's instruction below on lesser included offenses to assault in first degree intentional, and proceed directly to the court's instruction on count 4, assault in second degree intentional, Connecticut General Statutes 53A 68(2) below. All right, I am going to give you another 5 minutes just to stand up, take a break, and take a 5-minute recess because I know this is long.
Okay, I'm going to get us to the point of the fourth count. I'm not going to have her go through all of the lesser includeds because that's what's taking so long is, and then we'll kind of do a summary and then we'll do the verdict. And then I'm thinking that I may try to do some on the fly type of research on some of these parents. So stick around.
To talk to you now about lesser included offenses to assault in the first degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses under count 3 if and only if you have unanimously found that the state has not proved beyond a reasonable doubt all the elements of the crime of assault in the first degree intentional, and therefore you have found the defendant not guilty of assault in the first degree intentional at count 3. The defendant at count 3 of the substitute information is specifically charged with the crime of assault in the first degree intentional. The offense of assault in the first degree intentional under our penal code is such that it may include the elements of the crimes of assault in the first degree reckless and assault in the second degree both intentional and reckless. Similar to count 2, this brings into play the rule of law known as lesser included offenses at count 3 as applicable to the crime of assault in the first degree intentional. You will consider lesser included offenses as to count 3 in the order and under the circumstances instructed herein. The fact that I am instructing you on lesser included offenses to assault in the first degree intentional at count 3 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the first degree intentional or is guilty of any respective lesser included offense. You will first consider the lesser included offense of assault in the first degree reckless directly below its subsection A. You'll proceed to the court's instruction A, assault in the first degree reckless, Connecticut General Statutes 59A3 directly below. A, assault in the first degree reckless, 53A, 59A3. Statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a risk of death to another person and thereby causes serious physical injury to another person. For you to find the defendant guilty of the charge, the state must prove the following 4 elements beyond a reasonable doubt. Element 1, conduct creating a risk of death. The first element is that the defendant engaged in conduct that created a risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstance when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You'll refer to the court's previous instruction on recklessness at 16. Element 3, extreme indifference to human life. Third element is that the defendant acted under circumstances evincing an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, cause serious physical injury. Fourth element is that the defendant caused serious physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. You refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Thomas Connery Jr. was injured as the result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury. It is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury, which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. In summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a risk of death. 2, he acted recklessly. 3, he acted under circumstances evincing an extreme indifference to human life. And 4, he caused serious physical injuries to Thomas Connery Jr. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the first degree reckless, you shall find the defendant not guilty of assault in the first degree reckless at count 3, and you shall then consider the lesser included offense of assault in the second degree intentional. We'll proceed to the court's instruction on B, assault in the second degree intentional, Connecticut General Statutes 53A2 below. 53A-16A2 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the first degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. You'll refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory exceptions beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 of count 3, at count 3. This will end your deliberations at count 3. You will not consider any additional lesser included offenses under count 3. You shall move on to deliberate count 4. You'll skip subsections B and C below and proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A, 68A2 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the first degree reckless at count 3, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 3. You will not consider any other lesser included offenses under count 3. You shall move on to deliberate on count 4, skip subsections B and C below, and proceed directly to the court's instruction on count 4, assault in second degree intentional, Connecticut General Statutes 53A, 68A2 below. B, assault in the second degree intentional, Connecticut General Statutes 53A, 68A2. You will deliberate on this lesser included offense if and only if you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree intentional, and therefore you have found that the defendant is not guilty of assault in the first degree intentional, and further, that you have unanimously found that the state did not prove beyond a reasonable doubt all the elements of assault in the first degree reckless, and therefore you have found the defendant not guilty of assault in the first degree reckless at count 3. The statute defining this offense reads in permanent part as follows. A person is guilty of assault in the second degree, but with intent to cause physical injury to another person, he causes such injury to such person by means of a deadly weapon or a dangerous instrument other than by means of a discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result. When his conscious objective is to cause such a result, you will refer to the court's previous instruction on specific intent at 15. Physical injury is defined as impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious. It may be minor. Caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injury. You will refer to the court's earlier instruction on proximate cause at 14. You must find a proof beyond a reasonable doubt that Thomas Connery Jr. was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to the person or to some other person. Element 3, with a dangerous weapon. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of a discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person. 2, the defendant did cause physical injury to Thomas Connery Jr. And 3, the defendant caused the injury other than by means of the discharge of a firearm. If you unanimously find that the state has failed, if you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of assault in the second degree intentional at count 3. And you shall then consider the lesser included offenses of assault in the second degree reckless. We'll proceed to the court's instruction on C, assault in the second degree reckless, Connecticut General Statutes 53A, 68A3 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claim of self-defense and defense of others. You'll refer has proved beyond a reasonable doubt that the defendant did not act in self-defense or defense of assault in the second degree intentional in violation of Connecticut General Statutes 53A, 61-2 at count 3. This will enter deliberations at count 3. You shall not deliberate on any lesser included offenses. You shall move on to deliberate count 4. We'll skip subsection C below, proceed directly to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 68 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, elements of that crime proven beyond a reasonable doubt, this will end your deliberations at count 3. You shall not consider any other lesser included offenses, and instead shall move on to deliberate on count 4. You will skip subsection 3 below and proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes, section 53A 68 below. C, assault in the second degree reckless, section 53A 68. Statute defining this offense reads in pertinent part as follows: a person is guilty of assault in the second degree and guilty of this charge. The state must prove the a person acts recklessly to occur, or that such circumstances exist or injury. The second element is that the defendant caused.
I'm skipping this because this is about the seventh time we've heard it.
Beyond a reasonable doubt that Thomas Connery Jr. was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more. Official injury, it is defined by serious loss or impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element means any instrument, article, serious physical injury means serious physical injury, which creates instrument. Element 3. Serious physical injury means serious loss or impairment of the function of causing death or serious physical injury. Dangerous instrument if, under the circumstances of its use or threat, and 1, the defendant acted recklessly. 2, the defendant caused serious physical injury to Thomas Connery Jr. and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 3. This will end your deliberations at count 3. You shall next move on to deliberate on count 4. Proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 68 below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense, you shall find the defendant guilty. Will end your deliberations at count 3, and you shall then next move on to deliberate count 4. You'll proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statute section 53A 68 below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt, then elements of that crime proven beyond a reasonable doubt, this will end your deliberations at count 3, and you shall move on to deliberate on count 4. So you will proceed to the court's instruction on count 4, assault in the second degree intentional, Connecticut General Statutes 53A 68 immediately below. All right, ladies and gentlemen of the jury, it has been a long day of sitting, and we are about a little over, I would say, 3/4 of the way done with my charge. However, it is 4:30, so I am going to go ahead and I am going to adjourn for the day. So what that means is, go over this again. You have heard all the evidence, you've heard closing argument, you've heard part of the jury charge, part of the court's instructions to you.
Sweet niblets, y'all. I'm going to try to find, I don't know that I'll find anything on the finishing of the the jury instructions, but I think I can break it down for you. And bear with me. We're going to do this quickly so then we can go to the verdict, and then we can try to do some live time research. So starts out with count 1. Count 1 is murder. If they find not guilty on murder, then they have to go to the lesser included charge, which then is manslaughter, first degree intentional. Then if they find not guilty there, then they have to go to assault. I'm trying to check my notes here while I'm telling you all. Assault in the first degree intentional. Then if they find him not guilty on that, then they have to go to second degree assault. I'm sorry, assault in the first degree reckless. And then if they find him not guilty of first degree reckless, then they have to go to second degree assault intentional. Then if they find him not guilty of that, they have to go to second degree reckless assault, second degree assault reckless. So that's why she's having to read so many of these, because she's having to read every single lesser included charge and how they need to do it. And then in each one of those lesser included charges, y'all, they then also have to consider self-defense. And if they consider self-defense, then even though they find him guilty of whatever that lesser included is, they could still deem it self-defense and he would still be acquitted. So this is why it's so confusing. Now I understand, after hearing the jury instructions, why they were hung on so many lesser included, because it's like you're getting every bite at the apple all the way down. Yes, Melissa, I think it's crazy too. Allison, I cannot cover anything Monday night as much as I want to. It is Mr. Demeanor's birthday Monday night. So I will not be doing any sort of socials or live streaming or anything on Monday. So next week will be a little weird. I'll definitely do Wine and Crime Wednesday. Tuesday, just to give everybody kind of a quick, since this came up, a quick deal. Tuesday is Kelsey Fitzsimmons' birthday, and I will be on a live stream with Calling All Beings and several other people, trying to raise some funds for her defense and celebrating her birthday, since her birthday is Tuesday. So just a little heads up on that. So I'm going to head back and see if I can find, here's the verdict here. So does everybody kind of follow what all of that is? It literally is like so what count one is, the actual charge for count one is murder in the death of Jimmy McCrath. Oh, YouTube's not going to like that word. Oh, well. And then the second count is assault in the first degree intentional on Ryan Hines. And then they have to go through all of the lesser includeds. The third count or charge, whichever you want to call it, because she said at the beginning they use those interchangeably. They're used synonymously. If anybody watched the Amber Heard Johnny Depp trial, you'll know what I'm talking about when I say that. But anyway, so the third count is assault in the first degree intentional, and that is also that's the same charge as Ryan Hines. This is on Tommy Connery. And then the fourth count is assault in the second degree intentional, and that is on Faison Teal. So that's how this is all going down. So now when we get ready to listen to what the verdict actually is, it should make a little bit more sense to you, I hope. Let me get us organized here. And
Birthday presiding, good morning, Your Honor.
whew, this is all about them being hopelessly deadlocked. We want the actual verdict. We don't care about all of that. Correct, everybody? Let's get to the verdict. All right, here we go.
All right. Because as though all of our juror members are present, I would seek the counsel's stipulation as such before I begin.
Say we'll stipulate the presence of the jury. Defense stipulation, Your Honor.
So I first would like to inquire as to the foreperson. Mr. Foreperson, please just stand. Thank you. All right. So, Mr. Foreperson, I did receive a note that was signed by you, and it was timestamped as well. The note indicates to the court that the jury, although unable to unanimously agree on some charges, has unanimously agreed as to a verdict on murder at count one and manslaughter in the first degree intentional at count one. Also, as to counts 2 and 3, the jury has a verdict on assault in the first degree intentional. And then lastly, as to count 4, the jury has reached a verdict as to assault in the second degree intentional. Is that correct?
Yes, ma'am.
All right. So at this point in time, I would ask you to be seated.
I forgot I muted myself. So just a quick synopsis. What they're saying is they have a verdict in the count 1, which is murder, and the lesser included of manslaughter in the first degree. They have a verdict in count 2, assault in the first degree. and they have a verdict in count 4, which is assault in the second degree. All of those are intentional. That's why I didn't say it. So that's kind of gives you the framework of what we just talked about. I hope that makes sense. So here we go.
All right, the court at this point in time is going to move forward with a verdict that you do have relative to the counts and the charges that you have relayed in the note and that you have just confirmed on the record. So Madam Clerk is going to be providing to you additional instruction as she accepts that partial verdict. Okay? Thank you.
Ladies and gentlemen of the jury, as your names are called, please indicate your presence by answering here, rise, and remain standing. All but the foreperson may be seated. Mr. Foreperson, in the case of State of Connecticut versus Raul Valle, has the jury agreed upon a unanimous verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at counts 2 and 3, and assault in the second degree intentional at count 4?
Yes, we have.
Will the defendant, Raul Valle, please rise and face the jury? Do you find the defendant guilty or not guilty?
Not guilty.
Okay. We have to go through it in docket number 8.
Oh, it's not on there. Sorry. In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle, with the crime of murder in violation of section 53A-54A (a) of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55 (a) (1) of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
We're going to direct the court's inquiry to the foreperson at this time. Mr. Foreperson, your note indicated, and that's exhibit 10, court exhibit 10, your note indicated that the jury, after making deliberations, was hopelessly deadlocked on manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A-55A3 as a lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge. Is that correct?
That's correct.
Madam Clerk, please continue on with count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59 (a) (1) of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, court exhibit 10, again, the note that was sent to the court, provided to the court and left, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked on the charge of assault in the first degree reckless in violation of 53A-59A3 as a lesser included offense at count 2. Is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as a lesser included offense. That is correct.
That's correct.
Thank you. Madam Clerk, please continue on to count 2.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59 (a) (1) of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Again, Mr. Foreperson, exhibit 10, court exhibit 10, your note to the court indicates that with respect to assault in the first degree reckless under count 3 after lengthy deliberations, the jury is hopelessly deadlocked on that charge of a lesser included offense. Is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree reckless in violation of Connecticut General Statute 53A-59A3 as a lesser included offense under count 3. Is that correct?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60 (a) (2) of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, court exhibit 10, the note that was forwarded to the court indicates that at count 4 as to assault in second degree reckless after lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision as to assault in second degree reckless in violation of Connecticut General Statute, section 53A-60A3 at count 4?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed.
Your Honor, may the verdict be accepted and recorded.
Yes, the verdict shall be accepted and recorded.
Ladies and gentlemen of the jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of section 53A-54A (a) of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55 (a) (1) of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59 (a) (1) of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the third count of the substitute information, charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, parent A, parent 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the fourth count of the substitute information, charging the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, parent A, parent 2 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
Ladies and gentlemen of the jury, please rise. You heard your verdict as it was accepted and recorded. You heard your verdict being read back as to each of the 4 counts. Is that your verdict? So say you all.
Yes.
Ladies. Anything from counsel at this point?
No, Your Honor, may we be seated?
I'm sorry?
May we be seated?
Yes, you can be seated. All right. On no request, the counsel, the court is not going to hold the jury. I won't have the poll. All right, ladies and gentlemen of the jury, I'd like to address you. Take a moment. Your verdict has now been recorded. It's been accepted by the court. The court will deal with the outstanding remaining charges once I discharge you, but I want to say a few words to you before I do that. Your oath that you've been obligated to keep during this time, you've been obligated to stay silent, not discuss this case. I am now relieving you of the duty of your oath, so you are released from your oath. It is, of course, up to you to do so. I would like to do this. This takes you away from what we originally did.
I'm fast forwarding because I want to hear what they say about new charge.
The decision that you make here today is not a goal to you for performing to these proceedings. You instantly remain dead. However, there are with the court. I would appreciate if you would stay back here at the courthouse for a little bit. There are some matters. Attorney Smith, at the end of evidence, at the close of evidence, you moved for a judgment of acquittal on the 4 charged offenses, paying most attention to the murder charge at count 1. The defendant has since been acquitted as of all of those charged offenses in the substitute information. What is your position relative to the motion for judgment of acquittal on those 4 offenses?
Withdrawn, Your Honor.
So the court's going to hear that for the record. With respect to count 1, manslaughter in the first degree reckless, Connecticut General Statutes, section 53A, 55A3, count 2 and 3, assault in the first degree reckless, Connecticut General Statutes, section 53A, 59A3, and count 4, assault in the second degree reckless, Connecticut General Statutes, section 60A3. After the jury's inability to reach a unanimous verdict, the court was going to memorialize on the record the following. On day 1 of the jury having the case, after about 2 hours of deliberations, the jury sent a note stating that it was hopelessly deadlocked on the murder at count 1. The court, upon agreement of counsel, instructed the jury to continue deliberating, instructing the jury to review the evidence, discuss and consider the opinions of other jurors, to explain views and listen to the views of others, including the majority, to listen to what the minority had to say, and the minority to listen to what the majority had to say. Subsequently, after a total of about 5 hours of deliberations having passed, the jury sent a second note to the court indicating that the jury was deadlocked on murder at count 1, not guilty of first degree assault intentional, deadlocked on first degree assault reckless at count 2, with the same indication for count 3 on the same charges, and not guilty second degree assault intentional, deadlocked second degree assault reckless at count 4. Once again, upon agreement of counsel, the note was disclosed to counsel. Obviously, it was reviewed, it was discussed, and I directed jurors to continue deliberating, instructing the jurors to review the evidence, see if any evidence was overlooked or misunderstood, to explain the views and listen to the views of all other jurors. The jury continued their deliberations into the 3rd day. And now, once again, on this 3rd day, after more than 11 and a half hours of deliberations, the court received a note from the jury, now Court Exhibit 10, indicating a partial verdict, and that as to the other charges, the lesser included offense. I'd also like to take a moment to address everyone. I first would like to address counsel and thank them for their courtesies to the court and to each other during the course of this trial. Also to the family members, all of them, the spectators that have been present in this courtroom every single day. I want to thank you for heeding the court's expectations as to courtroom decorum. I know that this was an extremely emotional trial, and I appreciate the conduct that was displayed continuously throughout this process. Once again, I understand that a jury's verdict will never fully satisfy one side or the other. Not everyone will walk out of here satisfied today. And I apologize for that, but this is the process that we have, and the court believes it to be a fair process. I also want to indicate that my appreciation to courtroom decorum extends to every single member of the media. I think you've portrayed this matter as fairly as possible in the news, and I think that your courtroom decorum here, in following all the rules that were placed on the media by way of court order, have been met with professionalism in terms of your business and your duty to your job. So I want to thank you for that. At this time, I'd ask counsel if there are any other matters that the court should take up.
Nothing from the state at this time, Your Honor.
Not from the defense, Your Honor.
Lastly, I would like to address Mr. Valley. Mr. Valley, you too have shown respect to the process in terms of your decorum and your behavior and conduct here in the courtroom. You have been acquitted of the 4 charges that were held against you and stated in the substitute information. So at this point in time, I wish you the best of luck moving forward.
Thank you.
Counsel, thank you. Thank you to everyone. Court stands adjourned.
All rise. Court's adjourned.
Okay. So, all righty. I'm going to pause this. I'm going to get us going here. Yes, I want to give him a hug too. I'm trying to keep it together pretty good here. So, questions here. I do not know whether he had why Kevin Smith is not his attorney for the next case. I don't know if he has a new lawyer. I assume he does. We'll find that information out on Monday. And so kind of, if there's a GoFundMe, I don't know what it is and I can't find anything. I've put feelers out. I have no idea because yes, I thought it was a financial issue as well. So, it's later in the day, so I'm going to try not to have my asthma bother too much. So, okay. So what happened is what they can go back or what they're charging, at least this is what I believe is happening. What they are charging him with now is first degree manslaughter, reckless. That is count 1. That is for Jimmy McGrath. Count 2 for Ryan Hines, Mr. Smirks a lot. That one, they would be charging him with first degree assault, reckless. Count 3, also second degree assault, reckless. And then Faison Teal, the fourth count, the third one was for Tommy Connery. The fourth one will be for Faison Teal, and that is also second degree assault, reckless. So basically what I'm hearing the jury say, they did not feel that Raul went to that party intending to stab a bunch of people, injure them, and take the life of one of them. That is how I take that. Okay, let me see what I can find as far as what's happening with the parents here. So bear with me. I feel like there was something else I was going to bring up. Oh, I did think it was funny in the closing arguments when the prosecutor said that, how did he put it? Why didn't he come to the cops? Why didn't he turn himself in to the cops? Hang on. This is Connecticut. I'm in the wrong state over here. And I thought to myself, oh my goodness. Can you imagine if Raul would have gone voluntarily and talked to them? Y'all, think about that. Oh, and Lori, there's a juror interview. Oh, send me a link or tell me where to go or something, because yes, I'd love to hear what a juror has to say. And as far as the parents, the first one I looked up was Tyler Rich Parents in Connecticut. Nothing comes up for that. But what does come up is William and Amy Da Silva. They're facing 7 total civil cases filed by the 4 stabbing victims and their families. Oh, let's see. Here's one. Family drops lawsuit against owners of Shelton Home. Hang on, my computer's thinking here. Where teen was fatally stabbed. All right. A lawsuit by the family of Jimmy McGrath, teenager who died. This was recent. This was September 5th. It just says that they've withdrawn. Wow. They withdrew the lawsuit against Tyler Rich and his father, Ronald. How do you like that? NBC Connecticut knew. I need more information, Lori, like where I need to go to search for that. So I'm going to go back here and see. I'm just trying to find out anything about any of these parents because, yes, I feel like Tyler Rich's parents there should be more about that particular situation. And this one says NBC Connecticut. Is that what you're talking about, Lori? This one says one civil case settled, others active in connection with deadly Shelton fight. Oh, it's telling me I have to sign up. Let's hope not. Kevin, I'm reading here. Hold, everybody, hold. This is, live stream jury. You just Googled live or jury interview. Okay, hang on a second here. I want to find out what settled. The 3 other stabbing victims also filed civil cases against the couple. First civil case was filed in 2023 against Paul and Susanna Leifer for the first party at 5 Lazy Brook. Yes, Danielle, I would think their homeowners would cover this. Yes. The individual cases were consolidated and agreement was okay. The 3 other stabbing victims, Ryan Hines, Faison Teal, and Thomas Connery, also filed civil cases against the couple. The individual cases were consolidated and an agreement was reached on April 29th, 2025 for $500,000. Court records show the insurance company didn't immediately pay, prompting another filing by McGrath. I'm going to keep here. Let me share this with y'all and we'll just kind of putz through this. And then we will definitely get to the juror interview if I can do that. Let me stop sharing that. I got to pull something else up. So then you all can see what I'm looking at. How's that sound to everybody? Oops. There we go. Let me see if I can make this so we can see it a little better. Okay, that's like really big. Let's try that again, shall we? I'm a professional here. Just so y'all know, I'm a professional. Okay. What is everybody saying here? Faison Teal was a big boy with a little cut. Come on now. Okay, so civil case settled, others active in connection with deadly Shelton fight. This is what I was reading earlier. Several lawsuits. Let me just scan through here. Okay. We're at the top. Okay. It's not over, right? So there's still some things that need to be resolved. Kevin McGrath vowed to find justice for his son, Jimmy McGrath, after the not guilty verdict for Raul Valle. His attorney reiterated that effort outside of court. Stream, Connecticut. Yeah, blah, blah. We will still be pursuing justice to hold anyone that bears any responsibility that led to the chain of events that night. McGrath and his wife, Margaret, filed several lawsuits in connection with the events of that night. NBC Connecticut spoke with attorney Trent Lalima about the differences between criminal and civil cases. Lima is not affiliated. We don't care about that. We know there's a difference between criminal and civil. We're smart like that here. Us jurors are educated. The state of Connecticut has the burden to prove the case beyond a reasonable doubt. They don't prove it beyond reasonable. Yeah, we know all of this. That's what I was reading. The $500,000 that was settled The second and deadly fight that night was at the home of Ronald and Stacy Rich at 43 Laurel Glen. McGrath filed a wrongful death case against the couple, detailing what is alleged that they could have done to prevent the fight in which Jimmy was killed and Hines, Teal, and Connery were stabbed. McGrath also separately filed a wrongful death case against Tyler Rich for allowing teens to drink alcohol at the home. Documents say alcohol was a contributing factor that night. I would say so. Don't y'all believe that? On the stand during the criminal trial against Valle, Tyler De Silva detailed the communication between the teens after the fight at Lazy Brook, but before Laurel Glen. Yeah, we know this stuff. Yeah, the mother came down and shut it off. That's why the lifer party ended. I actually feel kind of bad for the lifers because I have a feeling they didn't know just how enormous everything was. But at the same time, you were letting a party happen, post-prom party at your house. Numerous defendants, the lifers settled. The latest information on the cases against Ronald and Stacy Rich and the separate case against Tyler Rich are on the schedule for jury selection. The case against the lifers was settled. Oh, interesting. Let's that was July. Wonder if there's more. Okay, let me let me see what I can find with the juror interview. So did you just type Lori Raul Valle juror interview? Let's see what comes up. Jury form. Oh, look at this man right here. Okay. Let's see if it's going to let me. Okay. Oh, let me turn the volume down on this because I had it so high for that court. And I got to change screens again. Bear with me here. Yeah, that's not right. Did I mention I'm a professional? Yeah. Let's, I'm going to try to relink the screen I'm trying to share. And I hope this is a Bing video. There we go. Looky there. Okay. Are y'all ready?
On the coverage, especially on the social media and that side of it.
I'm going to start him over since we missed how the beginning of this was.
Almost everything was an inconception on the coverage, especially on the social media and that side of it. The glaring one that stands out was the whole issue of self-defense. Out here, they made a big issue of the self-defense as if that had an effect on the trial. Actually, we went according to the jury instructions from the judge and the printed. Self-defense had nothing to do with any of our deliberations, because the rule was that we first had to, until we vote on a conviction of a guilty on one of the charges, we weren't even to consider the idea of self-defense.
Right.
All the deliberations were about, did the prosecution prove each element of the charge? That's another misconception. The vote was actually 11-1 for not guilty. That was within minutes after the first vote we took in the beginning. It was 11-1, and we spent the next 2 hours either one side trying to convince the other, and that's why after 2 hours of trying to come to a resolution is when we realized we were deadlocked on that one charge.
Wow.
It was because it was such a serious charge. And what happened was one young unarmed man got stabbed in the heart and killed. And that just, your first impression is murder. And that was the impression that it was awfully hard to get over, that it, even though it was a terrible thing, when we looked at the elements that had to be proved for a murder charge, it just didn't fit at all. And so it took some time. Matter of fact, early that following morning, It might have been even overnight when that person changed their mind. I can't speak to that. But the first thing the following morning when we resumed deliberations is when it was unanimous that it was not guilty on murder. Some of the
Wow.
elements early on were fixed, were definite, that there was a weapon. He did use a weapon. He was the only one that had one, so he must have caused everything. And like you were saying, that the disagreement was, what was his intention at the time he actually did the actions? And those words are pretty descriptive. Was it intentional? Did he really mean to do all those things at that time? Or was he just being, what the word they use is extreme indifference. Was he extremely indifferent to what might happen if he did those things? And that's what the other 11 hours of deliberation was all about.
Wow.
Was the deadlock on the charges you remained deadlocked on at the end of the deliberations? Were those 11-1 as well, or were they all different? Or
Yeah, when we went back into the courtroom, it was all 11-1 on every charge.
was it the same holdout
Wow.
as
No, a different person.
the? Oh, okay.
And the deadlock was 11 guilty, 1 not guilty. That's hard to say. I mean, I did say it was important just to get another point of view, his point of view. And I think maybe the only difference might have been the intentional reckless part of the deliberations. You know, I think we would have come to the same conclusions, but just wouldn't have been intentional, or reckless is where we would have been held up on.
I'm with you now.
And was there the same instruction on the extremely indifferent or reckless charges regarding self-defense? In other words, if you had gotten to guilty on those, would you have then considered self-defense at that point?
Right, and yeah, we completely didn't even think about self-defense unless and until we came to a guilty verdict on one of the counts. And so there was the whole pages and pages of instructions on self-defense that we never even got to. I wouldn't say one, but I would say what was more important or relevant to us were the ones that couldn't be denied. It was the Ring camera doorbell footage, the cell camera footage, the testimony from the medical experts as to the nature and the causes of the wounds. What we really struggled with, like I said, there was so much testimony, and so much of it was contradictory,
Yes!
or inconclusive, or so that's the part that we really had to go through, and seriously consider what was and what wasn't the truth. But there wasn't any one thing that stood out over the others. Yeah, it's a part of it, and again, the fact that he brought a knife would have to do with the argument about intentional or reckless. And part of that is there was a lot of conflicting testimony about, did he ask for the knife? Did he know whether it was a knife? Or during the altercation in between, did someone just throw the knife to him? And there was a lot of conflicting testimony on that point. And so we really couldn't come to a conclusion whether he even knew there was a knife before it was thrown to him. And so we really couldn't use, we know we had one, but that's about all we could definitely tell about the knife.
When the prosecutor, I think, was
Interesting.
on the cross-examination, he asked him about reaching into his pocket and then unfolding it, like the fact that he had to take it out and unfold it. Did that play any part in the discussion of intent or any of the deliberations?
No, we talked about that a little bit, but some of the people indicated that it's not, you don't have to make a certain effort to open that knife. It could be done in a fraction of a second. And so the fact that he had to open the knife really didn't come into it, especially on the Jimmy McGrath case, because he already had the knife and it was already open before that part of it even began to happen. And that was the issue, that we had the testimony reread to us, Raul's testimony, and it hung on what did he know about Tyler Da Silva, his friend at the time. Did he know that Tyler Da Silva was out of danger and on the street, or did he? The last thing he said about seeing Tyler Da Silva was he was still on the ground,
Yeah,
getting beaten on. And so part of that was, and he said he wasn't going to leave his best friend there. And so did he know that Tyler De Silva was out of danger, or did he have no idea where Tyler De Silva was and he was going back for that reason? And so that's what, and that was never conclusive either about what he knew about Tyler De Silva at the time.
But, and just to clarify, that's only with respect to his intent too, because you're not saying it was self-defense of Tyler De Silva that
Or not even self-defense, but
or
considering
defense of
the
others,
whole, the whole
Okay.
process there. Yeah, it did, not in a big way, because not even being aware of that before the trial started, and it was actually the prosecution who brought up the fact that, and how those deals all happened. And so even according to our instructions, we were to consider it as far as the credibility of their testimony, but just because they got a deal, they were still required to tell the truth. And so it was a factor, but not a really significant one.
Too bad they
wouldn't have
didn't.
Changed, I think, our decision one way or another.
And in terms of the rest of the witnesses, was it just a case of trying to piece together what was common among all of them and what you could confirm through other means like the ring camera and medical testimony?
Yeah, some of it could be confirmed, corroborated, and some of it was conflicting. It was also, it just seemed to us that a lot of the testimony on the questions that could have been a negative thing for Valle, they had pinpoint, they directly realized everything. And on the other questions where it might not have supported the case, they didn't know.
Yay!
And so that seemed to be a factor also, that not all that testimony, even though there was a lot of it may not have been believable. Yeah, I think even without the witnesses that said they actually saw it, we really knew he did stab him. And again, the question was, did he know or think or mean to actually kill him when he did that? And the conclusion was that it couldn't have been.
And was there any single piece of evidence or anything that or his testimony that you found in common in finding that conclusion? Or
Yeah, well, between his testimony and even the testimony of the medical experts, that in order to kill him with that one stabbing, he would have had to hit him in the heart. And the heart being about the size of a fist, he would have had to known which ribs he had to go through and that the knife had to go straight into the body. And the idea that anyone, even not in a chaotic situation like that, who would know exactly where you had to do it to accomplish that? And also the other thing was, for the murder charge, he would have had specifically meant to kill Jimmy McGrath, not anyone else. And we just didn't think that was, he wasn't going for Jimmy McGrath, he was going for someone. Yeah, I think I said before, the most disappointing thing for us is that we couldn't come to a conclusion. And the fact that we couldn't change that one mind. And I would hate to see anyone have to go through this again. But yeah.
Oh, but it's
and
happening again.
One of the kind of misconceptions was, when you saw the headlines in the paper, all you saw was not guilty. And it wasn't we were saying that he was not guilty.
Right.
Just those specific crimes weren't proved. And so, you know, I apologize again. That's the one thing that got to us all, is that we couldn't get to that final conclusion.
Well, thank you, Lori, for that tidbit of information. I'm also going to see if I can find anything that shows the new charges. Oh. Bear with me, y'all. If you're still wanting to hang out and get a little bit more information on this, I'm going to see what I can find. What a smart jury. As someone who sat on both a criminal jury and a civil jury, I can tell you, if you are ever asked to serve on a jury, please go. Please do it. I have also been an individual in a mock trial in which we deliberated in front of attorneys so they could see how we went through the deliberation process. So also if you ever have the opportunity to do that, do it. It's fascinating and fantastic. I'm glad I kept you company all day, Lori Jean. Okay, I'm going to see if I can find the new charges, and then we will depart, and I won't see you all until Tuesday evening. Oh my goodness, will we be able to make it? Well, let's see, new charges. All right, Raul Valle faces new charges in Fairfield student case. Raul Valle, acquitted of murder by a jury, is now facing new charges in the Fairfield student case. New charges include first-degree reckless manslaughter, and then 2 counts of first-degree reckless assault, remember? And 1 count of second-degree reckless assault. So then the next thing we want to know are what kind of sentence. Yeah, I'm sorry, KS Granny. I know. I feel like I've been, we're all fast friends now, and I have to go to my day job tomorrow. Can we do something so that I don't have to do that? Gotta go there. Raul Valle, new charges. Possible sentencing. Let me look here. Here's what could come next. Let's see if it tells us on here. Nah, I don't want to know that. I want to know. Let's go to Connecticut. Assault sentence. Okay, here we go. So a first-degree assault, which, what did I say? It's first-degree assault reckless. Yes, KS Granny. I would love to call in for due to lack of interest. Yeah. That would be fantastic. I'm just trying to see if I can find anything, because I know it's different depending on whether it's reckless or intentional. At one time I had this because I had done like a little synopsis. I think it might have been a Wine and Crime Wednesday that I did it. And I had all of the information. Of course I don't now. So I'll just go through the assault charges. So they are looking at first-degree assault, a minimum sentence of 5 years in prison, second-degree assault. So he could be looking at 5 years, 5 years for Ryan Hines, 5 years for Tommy Connery. Second degree assault is 1 year for Faison Teal. And let me look the other one up here. Bear with me. Okay. First degree manslaughter can lead to up to 20 years in prison. And this is a first degree manslaughter. I'm trying to see if it tells me if if there's a minimum. There is no minimum associated with this. And even second-degree manslaughter, he could get up to 10 years in prison. So it doesn't show any sort of minimum with this. First-degree manslaughter can lead to up to 20 years in prison. Second-degree manslaughter carries a maximum of 10 years. So he's still not out of the woods with these new charges. And again, I have said this from the beginning. I'm not saying that there shouldn't be some sort of punishment. I just don't know what that is. I don't know what a good outcome for everybody would be in this particular situation. It's all ugly and no good has come from it. And there'll be lots of civil charges as we're seeing. Those are still ongoing. So I appreciate everybody hanging out with me and revisiting this trial. We'll be a lot smarter when the next one comes along. Again, scheduling next week. I have real life that's going to happen. So I have plans Friday night. I have plans Saturday during the day and plans Saturday night and Sunday. Sunday night, y'all. My team's playing Sunday night. The Detroit Lions are going to be playing Sunday night, so I definitely won't be available that night. And then Monday is Mr. Demeanor's birthday. And so I will definitely not be doing a live stream on Mr. Demeanor's birthday. But Tuesday, I'll be on with Calling All Beings. We're doing that fundraiser for Kelsey Fitzsimmons' birthday. And Wednesday, I'm planning on doing a wine and crime, and I might have a guest that'll join me that night. Don't know what we're going to talk about yet, but next week, make sure you look at my Sunday update because there is a ton of stuff happening next week in all the different courts. Like we have a ton of stuff. I think Brian Walsh hearing, Raul Valle hearing, possible Brian Walsh trial starting. Mark Sanchez has a hearing. Dr. Ebony Parker's trial, I think, is supposed to start next week as well. There's a lot, guys. So that's why I don't necessarily know that I'll have any specific topic when I do Wine and Crime Wednesday, because it might just be a little bit of everything. So I think there might even be a Kate Peter or a Turtle Boy or something. I mean, next week is packed. I feel like there is something going on in fact, I'm looking at the calendar. Oh yeah, Karen Reed has a hearing on Friday. So there's all kinds of stuff happening next week. So make sure you follow me. If you have not already, hit the like button. If you're over on the Twix, make sure you come over to the Tubes of You and smash that like button for me, the thumbs up. And I cannot tell you how much I've enjoyed this week and doing this and sharing all of this time with all of you. And you know, I always say, it doesn't cost a penny to be kind. So find someone to be nice to today if you haven't already. And remember, if we didn't learn anything else from this trial, you definitely should remember